Okay. Hi, everyone. We're going to have our slides up in just a moment. I'm not seeing them yet. Araceli.
Can everybody see them now?
Now
Yes,
we can.
yes,
Right.
we do.
This? Okay, let me just
Okay. Well, thank you, everybody, for coming to today's meeting to learn about conservatorship, how to get it, what's involved in that whole process. Araceli, if you can just slide on to the next slide, please. So for today, we have a pretty good roundup of individuals that are going to be speaking with you. Before I go any further, let me just say that today's meeting will be recorded, and therefore later on, if you're talking about challenges that you're experiencing with your loved one, please do not mention their name, because as that would be a violation of HIPAA for that to be caught and recorded and aired. So please refrain from using your loved one's name. So our meeting today is being hosted by NAMI Urban Los Angeles, and our presenters are Gail Evanguelidi with the NAMI Urban Los Angeles LPS Conservator, who is a LPS conservator and is known throughout Los Angeles and other areas as well, a go-to person. I'm Jim Farell. I'm with the Orange County Conservator Assistance Group. With us today will be James Kwon, Deputy Director of the Public Guardian's Office in Los Angeles, and also Linda Boyd with the Los Angeles Department of Mental Health. She's Supervisor of the DMH Care Court. And Venus Ngai will also be presenting with us today. She's from the Department of Health Supervisor Assisted Outpatient Treatment Program, and she'll be presenting on that. So with that being said, we'll go on to the next slide, if we will, please. Now, I also want to just take a moment to thank NAMI Urban Los Angeles for doing this. You know, they go to great length to support these meetings. So I want to thank the directors and all that's involved. Next slide, please. We'll be showing this slide later on in the program. You might want to jot down some phone numbers here on how to contact us, but you can call our numbers, or for those emails, you can reach out via email. If you have any questions, or if you're in crisis and you need direction, we're all here to support all of you. Next slide. So what is LPS Conservatorship? Primarily, it's an involuntary mental health treatment program. The essence of that is medication. It's to keep those with a very serious mental illness on their medications to help them keep their lives stable. And so, again, the essence of that is medication. Next slide.
And basically, the LPS conservatorship, and this is the way we believe, you have the right to be well, or they have the right to be well, because you're probably advocating for them. It's the LPS is the involuntary treatment. It's a tool for treatment which gives the person the greatest opportunity to regain their life through recovery. Now, we're going to be talking about other programs because LPS isn't necessarily for everyone, but you as their advocate have a pretty good idea which one might be best suited for them, and you can encourage the Department of Mental Health to get them in these programs. The people that run them, Linda Boyd for Care Court and Venus for AOT, they are amazing. They really are amazing, and we get good results. So, and if you have any problems with your team, don't hesitate to call them, because if they don't know there's a problem, they can't correct it. If they know there's a problem or somebody's saying something, and people say things because it's what they've heard, they just repeat it. If they know about it, they can fix it and correct it. So, and they do appreciate that, because we want these programs to work and to be well done. All right, next slide. Okay. When we're trying to get all of our ducks in a row, the things that you want to do is to build a powerful written case for treatment and acquire resources. Now, if you've called Social Security, they say, well, you can't apply, your loved one has to. And of course, they're not going to sign anything because they have a lot of paranoia. But we're going to work on how to get this done. SSI is if they have under 2,000 in the bank. So if they've got more than that and you can get some of it out, do that. SSDI is for people who have a work history. And Social Security knows their work history. I don't care if there were 16, 18. If they have so many quarters, then Social Security can help you with that. Sometimes Social Security is what they would have, depending on what the parent's situation is. When you call Social Security, they have the records on your loved one of their work history and things like that. They can determine which direction they will go. Those are income that come into the account. And you want to have a representative payee account with the bank. So the money's direct deposit to the account and only you will have access to it. It's to be used for them, but they don't have access to that money unless you give them the account number and the name of the bank. Then they're clever. They'll go get the money out of there. So you don't want to do that. Medi-Cal, Medicare, or private insurance, those are your insurances to help with get them in proper treatment programs. Do not, this is my suggestion, I don't suggest you use your bank account unless you're a millionaire or something like that. It'll be drained dry in a heartbeat. You can kiss your retirement, your vacations, everything goodbye. Because once the hospital knows you have money, guess what they're going to do? They're going to suck you dry. You don't want that to happen. So put your money away and don't tell people, oh, I've got money, I can do this. If you're a millionaire, go for it. But if not, I suggest you use county, and the county has pretty good programs. Next slide. SSI and SSDI, you start when they apply for it. Now, when you call Social Security, do not say the word, I am applying. That's a bad word to them. You say you need them to help you fill out the forms because you're going to give it to the social worker at the hospital when they're hospitalized and get the social worker to get them to sign it. And they'll help you fill out the forms so you'll have it all ready to go. Medi-Cal is granted usually when SSI is granted. And Medicare is usually granted 2 years after they're receiving Social Security disability income. But sometimes if you can prove that they've been ill for longer than 2 years, then you might be able to start the Medicare insurance at that time too. All right, next slide. Okay, we're going to write a powerful written case for treatment. I will tell you right now, no doctor, not when you're trying to get them into treatment, has the time to sit and listen to you tell them a whole saga of the whole situation. They just don't have that time. But and plus, that's verbal. Talk is cheap. When it's written, it's more powerful. So we're going to give you the tool to write a powerful written case for treatment, something that the doctor can look at in 3 seconds or less. They know there's a problem, and if they have questions, they can ask you. Next slide.
So you want to use the written case to acquire your Social Security, your SSDI, your Medi-Cal. You also want to use this very same document to request the police or a psychiatric team to hospitalize the person. Again, the same written information is utilized in requesting for AOT, FSP, or LPS, or the jail diversion programs. The social worker at jail is someone that you can provide this information to provide it to the treating doctor to initiate an LPS conservatorship, and we'll talk a little bit about that later on. It's also something that if your loved one has committed a crime while they were in psychosis, it can be utilized in court, or criminal court for the public defender, and you would give that to the public defender. It could also be used at the mental health court. Next slide. Araceli, there we are. Thank you. So when we're filling out the mental health history, we can't go to a doctor with, stacks of paper from other hospitals that you've been to with your loved one. You need to really boil it down very succinctly onto, if possible, one single page of paper. And this is what the front of that piece of paper would look like. It would have the mental health history as it's written here. Dates of that they've been hospitalized. As you're looking down here, you can see that they were homeless, that they were incarcerated, and so forth. As Gail said, the doctor can look at that in 3 seconds. He can say, oh my gosh, look what's going on with this individual. Look at all these dates and times and places where they've been hospitalized or other kinds of issues have been going on. So very important too, that when you're creating this mental health history, down at the bottom, you want to put any allergies that they might have to medications or what medications they're on. For example, you could put down, don't give Bioxin or Haldol, or that they have diabetes, that their health needs are being covered by Blue Cross insurance, that they have SSI or Medicaid, or that they've applied for Medicare, that type of thing. So the hospital knows what sort of information they have on a 5150 scenario. Next slide, please.
Great. Can I just say something?
Sure.
When you're doing your mental health history, you tend to want to put, we all do, tend to want to put down a lot of information. Don't. They put down only their first and last name, no middle initial, no middle name, no social security number, no birth date, because this is going to be used for a lot of people. If people need to know that information, they can ask you. And you always have a diagnosis. If you look at the homeless, the diagnosis is exhibiting psychotic behavior. They're not writing a book and doing research. It's exhibiting psychotic behavior. So if you don't have a diagnosis, put that down. Okay, next slide.
Sure. So you want to, again, as I had stated, include at the bottom of the history page a list of allergies, medications that they should not have, medical problems such as diabetes, heart, etc., resources available such as SSI and Medi-Cal. If they have an allergy to medications and it makes their tongue swell and shuts off their airways, that's very important to put down. They need to know this kind of information. Next slide, please. So on the back of this same piece of paper for the doctor, and let him know that there's information on the back for him to look at, we're going to go into the DSM-5, symptoms and characteristics. What is it that is going on with your loved one that is indicators that they're having a challenge with their mental health? Perhaps they think they see ghosts or dead people. As Gail once said, that, her family member thought she had this long pointed chin and so forth, big noses. Auditory hallucinations. If your loved one's sitting there and laughing as though they're responding to something funny that somebody said, but there's nobody around, it's just you and them, perhaps there's something going on in their head. They're hearing auditory voices in their mind that they're responding to. Or they may think that they have these great delusions that they're Christ, or that they're going to open a bunch of chain stores and make millions of dollars for themselves and the family, when the reality is they can't even get a job because of their mental health conditions. They may go to the hospital and thinking that they can raise people from the dead, or they may have very rapid speech. I was in a care center here in Orange County, and after so many times of mentioning this last issue about disorganized speech, I thought, gee, I've never heard that. I heard it once where this young lady with bipolar was just talking a million miles an hour. And I thought, how can you think that fast? How can you formulate words that fast and just talk incessantly, nonstop? And these are all signs and symptoms and characteristics of a mental health condition. Next slide.
I just want to say on the beaked nose and the pointed chin, after I picked my loved one up from the hospital and he was on medications, he looks and he says, Mom, you look so nice. I'm thinking I really wanted to say to him, yep, while you were in the hospital, I had a nose job and chisel my chin off. Of course, I didn't say that, but I sure did think it. Right. Disorganized behavior. There's a lot of disorganized behavior. They're incapable of following directions, and you can get frustrated. I mean, if you gave them a broom and asked them to sweep the floor, they might be sweeping in figure eights, circles, who knows where else, or maybe even outside sweeping, who knows. Leaving the stove on, parking the car in the middle of an intersection. There's out of control spending sprees, which is usually that's a bipolar, but that's schizophrenia also. Poor hygiene, and many of you have experienced that, going for days without showers. When you're putting this down, don't put 2 weeks or 1 week, just put excessive time without showering, smells bad or whatever. Paranoid thinking. We have people on the interstate that want to get out of the car when you're driving 60 miles an hour because of their paranoia. When you put your loved one in the car, put those baby locks on, including on the windows, because you never know what their mind is thinking, and you want to keep them safe if you can. It's some things that tend to run through people with these delusions. They have heightened sexual delusions. You've molested them. They've been gang raped. We've had men that are going to have babies the next day. We have some older lady. She was 65. She was pregnant and going to have a baby. These are all real to them. Heightened racial delusions. Those are also very real. Like one young man, and I've told this story before, he didn't like black people. I mean, he really didn't like black people. And his mom says, I don't get it. He's black. It doesn't matter. Anybody who is not them, they can become very racial against, whether it's the sex, the color, the skin, the religion, who knows? Those are things that tend to run through people with serious mental illness. And it's not 24/7. It could be today, but not tomorrow. You don't know. Behaves in accordance with their paranoid thinking, throwing food in the garbage because they believe it's poisoned, or having you eat it first to make sure it's not poison. Okay, if you die, just so they're not going to, as far as they're concerned. Um, Destroying their cell phones. A lot of people say, I just bought them 2 cell phones and they've gone through them. They give them away. They're not necessarily giving them away, they're getting rid of them, because many times they feel that information is being sucked out of their brain or it's being poured into their brain, and it's very frightening for them. They walk in front of traffic. They're oblivious to cars, and we've had people on I-10 doing that, or not I-10, but 405, and that is very frightening. But they're just oblivious to the cars, or they feel like they're immortal. So these are things that they're very real to them. Next slide. Believes in accordance to their paranoid thinking. We put down examples for you. You put your own example and only phrases. The doctors have heard it all before in one form or another. They don't want to sit and listen to, well, the sun was shining and, all this other stuff. They really don't. Just phrases. That's all they want. And it gives them a good idea as to what's going on, because in the hospital, they have food, they have a place to sleep, it's all well controlled, and they have shelter. When they're at home, they can't see what's going on. So you're being honest. Be honest. Don't you can embellish, but don't tell lies. That's one thing you don't want to do. And put down what the things that you have observed. These things are very, very important. You can read the rest and go through it and put down specifically for your loved one, but only phrases. Next slide. Next slide. Thank you. Tips. Don't mention substance abuse. This is what we used to always say. Now, the new law as of January 1st, substance abuse is a reason for an LPS conservatorship, providing it's causing them not to be able to provide their food, clothing, or shelter. So I'm not sure whether you should mention it now. If you're applying for AOT or care court, absolutely go ahead and let them know. They need to know what they're dealing with and how to help your loved one. In the hospital, I'm not so sure because the definition for gravely disabled has expanded. But right now, the hospitals aren't wanting to do LPS conservatorship. So it doesn't matter what you say gravely disabled is. If they're not going to do it, they're still not going to do it. They used to use, well, they still do, substance abuse as well. This is a substance abuse problem. So they discharge the patient. I can't tell you what we're going to run into as of January. They're not supposed to be doing this, and we're Department of Mental Health is trying to get somebody to be at the hospitals to make sure that the person has a program to go into. And at that point, substance abuse, they should know about that. But when they're hospitalized, the hospital runs a test, so they know. Do not mention violence. If you mention that they beat the crap out of somebody, it limits where they can go for treatment because now they're a liability. When they're not on medication, they can become very aggressive. So I would be cautious about that. What you can do is say that they are highly aggressive towards the neighbors, towards people on the street, towards their mother, father, whatever. That works very well. And Linda Boyd in Venice knows pretty much what that means, but they can still work with the patient. Do not say they can come home. This is still a problem with the new definition of gravely disabled. Basically, if someone is willing to provide their food, clothing, and shelter, they are not considered gravely disabled. So when they go to the hospital, I am not saying put them on the streets. I don't like that idea. But when they go to the hospital, you tell the hospital they have no place to live safely. They cannot come home. If the hospital discharges them, which I wouldn't be surprised if they do, they're not supposed to, because that's really hospital dumping. I'd be sitting in the parking lot waiting to pick them up because I don't really like a person on the street. It's hard to find them, especially if they roam and go to different places. And then it's harder to get them into a treatment program. If they're at your house, we can get somebody there. But with that said, if it's a dangerous situation, they're threatening to hurt you and to do things, then, you might not want them at home. And I don't blame you on that. Okay. Don't ever blame yourself for whatever decision you make. You are in the moment. You know the situation. I don't care what Jim or I or anybody else has told you. You have to make that decision and you're going to live with it. So if we say, well, do this or do that, and you go, I don't think that's going to work right then, that's fine. I mean, you do what you feel is the best and to help your loved one. All right, next one. Common symptoms, we talked about it, the racial, the heightened sexual delusions, FBI, CIA, other people are following them. That's very common. And of course, they're not ill, you are. And they'll tell the police that you really have a problem and they should take you to the hospital. And that is so real to them. In fact, my loved one took me to the hospital to have me admitted. It was quite interesting. But if he had me admitted, it was going to be okay because I get a 3-day R&R. I wouldn't have to cook, clean, and they had to listen to me. But that didn't happen. They kind of put him in the hospital. So that's just the way it is. Next slide. Jim?
So gravely disabled defined. A person who's gravely, I can't talk straight today. A person who is gravely disabled is a person who is not able to provide for their own basic needs like food and clothing, a safe shelter, personal safety, or necessary medical care because of their severe mental health or substance use disorder. Also, the personal safety, the ability to survive safely in the community without involuntary detention or treatment. Also, it could be because of necessary medical care. A licensed healthcare practitioner a licensed healthcare practitioner as care that is necessary to prevent serious deterioration or existing medical condition. I don't think that's right, but not written right, but that is a case. If they were not on the medication and they were deteriorating, then that's also one of the factors. But if somebody else can provide them with their food, their clothing, and a shelter in a safe manner, then they will not be considered gravely disabled, and the LPS conservatorship will not be granted. So if somebody else, like their friend or a buddy, says, "Oh, no, I'll give them. They can stay with me. I'll make sure that they take their medication," that's going to undermine the whole legal process of getting them onto a conservatorship. So be aware of that. I'll just leave it at that. Next slide.
But I'm just going to say, if they have somebody, their pimp, their drug dealer, or something like that, you can tell the hospital that this person is not good, and you can put the hospital on notice not to even let them come in to visit them, that is their drug dealer or their pimp, because they will come in. We're best buds. They're going to come home with me. I'm going to take them home. And people have been discharged to these people. So if that is a problem, let the hospital know in writing. Talk is cheap, remember, so you want things in writing. Okay, next slide.
What Gail just before mentioned, I actually know of a case where that actually happened, where the individual was actually assigned by the courts to live with somebody who they themselves were not stable, had a mental illness, living on the streets, and the courts unwittingly put the individual onto the streets because of information that wasn't less than accurate. So anyway, I'll jump in here on gravely disabled further. These are indicators that they are eligible for being put onto an LPS conservatorship. They shelter. They may not come to live at my home. They have no place to live safely, cannot handle a shelter or board and care safely. This is something that you would be telling to the hospital while they're on a 5150, letting them know the circumstance. Food, that they lost significant weight from not eating, that they're paranoid of the food being poisoned or overweight because of compulsive eating. I remember one family sharing with me that their son, who was in the middle of a 5150, had shut off his insulin pump because they thought it was poisoning him. And he had diabetes, and the insulin pump was to keep him alive. So we had to make sure that the first responders, emergency responders, were made aware of that, and that we were able to get them into the hospital. Clothing, they take clothes off at inappropriate times or places, or they wear clothes for excessive periods of times. They smell, or again, especially if they're dual diagnosed, if they're taking something like methamphetamine, their temperature gauges internally does not register properly. And, especially if they're from the younger years where black was the color to wear. They have on a black sweatshirt, black shirt, black pants, black tennies, and it's, 110 degrees outside. They just can't determine that, this is overheating their bodies, and it puts their health at risk. They maybe, again, have a lack of insight into the illness, what referred to as anosognosia, and therefore they'll not take their medication, and they have an ongoing history of non-compliance. These are all things you want to share with the hospital during 5150 or other situations where you're trying to get them hospitalized and initiate the LPS conservatorship. Gail, do you want to throw something in there?
I do. We have, if you go to NAMI Urban LA, they have a resource section, and they have a paper on LPS conservatorship. They also have it on the guide, and I need to send them the new ones and update it. But this whole program, this whole written case, you can copy and paste it to a Word document, because it's not on a PDF, because it's a working document. You can copy and paste it to a Word document, then delete what doesn't apply and add what does. It makes building this case a lot easier. And on the gravely disabled, which I will be updating that too, use it verbatim, this shelter, just delete what doesn't apply. And if there's a him, her, and you're dealing with a girl, take the hims off. If it's a guy, take the hers off. Because when the doctors read it, if they see him, her, they go, they copy this from someplace and they will discount the entire paper. You don't want that to happen. This is made specifically for your loved one with what you've observed. Okay, next slide.
So basically, if you are a conservator, you alone will decide the direction for treatment. And you have various sort of treatment modalities that you can pick from. So the first one that you want to consider would be the recovery model. This would be something like the full service partnership, where you may have a program that has classes, you have counselors, you have therapy provided to them in that type of environment. Or it may be that they need to be seen in care court and decide the treatment modality there. Perhaps they don't quite qualify for conservatorship in such case, and Linda, I think, is talking about this later. Correct me if I'm wrong, Gail. But assisted outpatient treatment, AOT, Laura's Law. And that's where they don't qualify for the LPS conservatorship, but under Laura's Law, we can provide them services and work with them on that. The LPS conservatorship is involuntary treatment. So again, it's not like you're asking the individual to go in and get help. As a conservator, you have the legal right to place them into a locked facility against their will. And this is probably one of the very few ways that we're taking away their rights, their legal rights. And it is only because it's necessary to protect their life, to protect them from ending up in a situation where that situation could end their life. It's for their protection. So very, very important to consider all of these treatment modalities and pick what you feel is the best for your loved one.
I just like to add on the conservatorship. You hear people say that you're taking away their rights. When they are very ill, they have no rights. I mean, their mind is controlling them. With the LPS conservatorship, the only thing that sticks with it is they lose the right to refuse medication. And you as a conservator has that power to approve or disapprove the medications. So you want to work to get the right ones for them. So, I mean, you don't want them sitting around and being a zombie. That is not going to cut it. And I'm sorry, there are too many quack doctors that will tend to do that. And you can say, you have the power to say, no, change the doctor, find a doctor who's going to work to find the right medications for your loved one to give them back their life, what they need. But basically, the right to drive a car, enter contracts, and decide where they live, they can get all that back as they recover, get into recovery. They can get all that back and be under a conservatorship. So it's not such a terrible thing. It's to give the control to be able to give them the treatment to get their life back. It's really an excellent tool for treatment, but a lot of people think of it as such a bad thing, and it isn't. It's like if you need an operation, I mean, sure, that's kind of a bad thing, but if you need it, you need it. And once it's done, you'll do a lot better. All right, next slide. Hospitalizing a person. Okay, we've got problems on this. Basically, if the person's going to harm somebody or themselves, you can call 911 and ask them to bring someone to evaluate them to put them in the hospital for a 5150. That's your 3-day hold. That's when they're going to hurt somebody or themselves. Don't wait for them to harm somebody. For instance, if they have the propensity for hurting somebody, you call the police then. Don't wait a week later, because there's nothing the police can do if you wait a week, later. But you don't call 911 in front of them, because that's going to escalate the situation. Quietly go someplace else, make the call, tell them what's going on, and ask for them to bring somebody to do the evaluation. You want them taken to the hospital, not the jail. If they're gravely disabled, for instance, they're not eating, they're in their room, but you have to have access to be able to get to them. So if they're in an apartment, be sure you have the key that you can open the door to let them come in. Call access, have them send out the mobile response team. And if you need the police used to control the person from being a flight risk. Unfortunately, police are saying, well, we're not going to put our hands on them. So if they take off, that's the way it happens. And this all came about because a few hospitals, which were LPS certified, refused to do LPS conservatorships. Well, that's dominoes effect because they're all almost refusing to do LPSs. And consequently, the police are tired of taking the same person to the hospitals 15, 20 times. They go, we're here for crime. We're not to be this transport and these monitor all this mental health. So now they say, we're not going to put our hands on a person. And many times they just don't come to help out. So it's really gotten to be a catch-22. If I can make a suggestion, call your board of supervisors. We have 5 of those in LA, and talk to their mental health deputy, because they're the ones that knows what's going on. And you tell them that you want the board of supervisors to build a hospital in every division, every section. There's 5 sections for mental health where the doctors will initiate LPS conservatorships. Your voices are powerful, and this is one time you can do it without having to be concerned about a situation with your loved one. Okay, going back to this. When you're doing that paper, the history, symptoms, and gravely disabled, put on there 3 open-ended questions, because you've had it, you've probably experienced it. The police come out there, you're going to hurt anybody? Oh no. You're going to hurt yourself? Oh no. They don't qualify. We can't take them. That's what they'll say. You put 3 open-ended questions that will set them off. NAMI says you always want to diffuse a situation. No, you don't. If they need to go to the hospital, you don't want to diffuse it. And a question could be like, I understand the FBI has been following you. How can we help you with that situation? Or I understand your mother took your $2 million. How can we help you with that situation? Those type of questions to get them to talk. And that will help the police to be able to write the 5150, or the mobile response team to write a 5150 and put them in the hospital. Okay, Jim, you want to add anything?
Not at this time, no.
Okay, next. Hospitalizing, these are the terms they use. You have a 5150, it's a 3-day hold or 72-hour hold. Other states have maybe a 14-day hold or a 24-hour hold. They still call it a 5150. In California, it's 3 days. Then the person can go to the 5250. That history, symptoms, and gravely disabled paper that you put together, and you shouldn't have more than 3 pages of that. Give that to the police quietly. Give it to the police when they come over. It helps them to write a stronger case for treatment. Also, when they take the person to the emergency room, because that's where they'll decide where they're going to go, you go there too. The police can tell you where they go because that's civil. We haven't hit HIPAA yet. So you can go to the emergency room. You quietly give that paper to who's ever there to give to the evaluators. It will help them to write a stronger case. If they transfer them to another hospital, again, be sure that paper is given to the hospital where they're going, because now it helps them to write a stronger case. And if they have questions, they can call you. So you basically go on a 3-day hold, then you go to the 14-day hold. Don't assume the hospital's going to keep them for the full 14 days. They don't. They discharge them on day 11 or 12. And you're going, but they were supposed to keep them for 14 days. They don't. Now, it is after the first 4 working days, and they count the weekends as working days, of that 14-day hold, that they do a probable cause hearing, or another term would be a certification hearing. In other words, we have the ability to keep them for the full 14 days. If your loved one wins the case, the hospital has to discharge them at that point. If they don't win the case and what they're looking for is gravely disabled, then they can keep them for the full 14 days. They don't. They release them after day 11 or 12. But that paper will help to be able to keep that hold longer. It is after that probable cause hearing, which is right in the hospital, or the certification, whatever they want to call it, is when the doctor will tend to initiate the LPS conservatorship if they're going to do it. Now, if you have a hospital who says, well, this hospital, we don't do LPS conservatorships, you're supposed to keep a journal with everybody you talk to. Even when you call me and you talk to me, you put that down and just put LPS information. Otherwise, you're writing a thesis. You don't want to do that. But you put the name, the contact person, and what they say, and you can repeat it to them. Okay, Miss So-and-so, what you are telling me is that this hospital does not do LPS conservatorships. Am I understanding that correctly? Then you can call me, or you can call Connie Drexler with the Department of Mental Health, and report them. They will talk to them. They cannot make the doctor initiate the LPS conservatorship, but they can put pressure on that person. And if your loved one has a series of hospitalizations and homelessness, and they've been in care court or AOT and nothing's working, they put a lot of pressure on that. Okay, a 5270 is an extension of a 30-day hold. It's also known as a 30-day hold. And if the doctor has initiated the LPS conservatorship with the public guardian's office, they have 30 days for the public guardian to come out and evaluate them, petition the court for a court date for an LPS hearing, and whatever else information they need to know. This is the time where you tell the public guardian, and send that paper, send your history, symptoms, and gravely disabled to whoever is handling the case. You tell the public guardian that you would like to be the conservator. And if you need the conservator of the estate, we'll talk about that shortly, you tell the public guardian that also. Okay, next slide. Or Jim, did you want to add?
No, you're good.
Okay, how to acquire the LPS? God bless you on this, because the city is now working in every way they can to not do LPSs when really they should. It is the treating doctor in the hospital or the jail who can initiate the LPS conservatorship. With the exception of the home team, they can do it when the person's on the street. This is not the law, but it is the practice. And it's the practice because when the doctors write up this information, and they have to be a certified LPS doctor, hospital doctors are, and jail doctors are. When they write up the case, there's a lot of work that goes into this. If the person does not show up in court, let's say they're on the street and they don't go to court, case is dismissed. So that's why it's the practice. The hospital will transport them to the court. The jail will transport them to the court, or they'll do WebEx and have a hearing through WebEx. So that's generally the way it is, and that's the reason why they don't do it. The loved ones in your home, you want an LPS. They don't come to your home and write it up, because if they don't show up in court, all that work was for naught. Next slide. LPS via the hospital, I mentioned this, give it to the treating doctor in the hospital, or to the social worker to give it to the treating doctor. It's usually you work through the social worker. Request in writing that the doctor initiate the LPS conservatorship. And keep in mind, you can do that when they first go in on a 3-day hold, or the the 5150. But after it, the doctor normally will not initiate the LPS till after that probable cause hearing or certification hearing. All right, next slide. Request the treating doctor at the jail to initiate the LPS conservatorship. Give the treating doctor, you can send that through their social worker, the written case for treatment, and request in writing that the doctor initiate the LPS conservatorship. When the person goes to court for the arraignment, you can request the public defender get the mental health liaison involved in the case and get them in a jail diversion program. Those programs are pretty good. Now, what I learned yesterday, and I think James is going to talk about it today, if they're under a jail diversion program, they will not do an LPS conservatorship. But if you do the LPS conservatorship first, then they can have the jail diversion. I look at it this way, LPS, because it takes away their right to refuse medication. That's the basis of it. The others are temporary. If they're under a jail diversion program and they go off their medication, they're not going to finish that jail diversion program. The LPS is insurance policy to help them to do it, because if they go off their medication, you don't have to wait for them to decompensate to be harmed to self-harm to others or gravely disabled. As a conservator, you can request that the police transport them to the hospital. The hospital is the only place that can force the medications. And once they're back on medication, they're good to go, assuming you have the proper medications. If they've been 6 months under the LPS and they're hearing voices and they have all these delusions, that medication is not working for them. And you have the power to work politely with the doctor to say, let's try something different. And if the doctor doesn't do it, get another doctor. All right. Next slide. Jim?
So I'm a little slower on the draw, but I was there. The California Welfare and Institutions Code 5008.2. It is law, and the law requires that all health care providers shall take your information, and the historical course of the person must be taken into account for treatment. This was, I think, originally written by Carla Jacobs, as I recall, from Orange County. And it just means that you, as the family member, have all the legal right to provide healthcare providers all the information that, all the historical course of what's been going on with your loved ones. And they must take that into account for their treatment program. The court stated that harm may be through neglect or inability to care for oneself. Therefore, if they lack the provisional sense to care for themselves due to their mental illness, then they meet the criteria for a 5150. So again, the way that things are written up, as we've been talking about, is very, very important. Just know that that document that you've created must be accepted by the police department, 5150 responders, the hospital, anyone that's going to make a determination whether your loved one is going to be hospitalized or put onto a conservatorship. They have to accept your written information. Gail?
You covered it.
Okay, next. So criteria for LPS conservatorship. The LPS conservatorship is California's involuntary mental health treatment for recovery. You have to have both a serious mental illness and be gravely disabled. Serious mental illness is like schizoaffective or extreme, bipolar illnesses and those types of things that renders the individual what they call gravely disabled. So it helps a person with no insight into the illness and is also non-compliant with treatment and medication. Next slide. Again, as I mentioned before, serious mental illness, bipolar, schizophrenia, schizoaffective disorder, which is a combination of the first two, clinical depression, obsessive compulsive disorder, chronic substance abuse, which of course with a new Senate Bill 47 is going to all be a part of this. And all of these kinds of instances then are making the individual eligible for a conservatorship. Next slide. Gail?
You have two types of conservatorship. Now, in California, they also have another conservatorship called a probate conservatorship. Do not get that confused with LPS. Probate is for anybody who has a mental illness, not mental illness, but a brain problem, stroke, Alzheimer's, autism, anything with the brain. That is probate conservatorship, dementia, all that. LPS conservatorship only pertains to what Jim just talked about on the slide before, schizophrenia, bipolar, schizoid affective, and chronic depression, those things. That is LPS conservatorship. If you go to an attorney, and attorneys are notorious for this, if it is not an attorney that really understands LPS conservatorship, they will take your money. They will be doing probate conservatorship because you might not know the difference between the two. And when they get to court, the judge says, you're in the wrong venue. This is not the venue. This is a mental illness. This belongs in a different venue at Norwalk, not here. Case dismissed. And the attorney will say, I can't believe that judge dismissed this case. He should have never done this. As if he's totally innocent, as he's pocketed your money. So be sure if you hire an attorney, you understand what that attorney can do. They cannot make a doctor initiate the LPS conservatorship. And when the doctor is in the hospital, the other problem you have, the California law, and this is the California Welfare and Institutions Code, basically when the doctor or the hospital has discharged a patient, a mentally ill patient, they are not held liable legally or criminally or civilly. You cannot hold them liable for discharging a patient, which to me is wrong because it opens the doors wide open for hospital dumping, which is what we get. So complain about that to your legislator to change that. Your voices are very important. And the more they hear these things, the more they're doing something about it. But they don't understand mental illness. They've never lived with somebody with a serious mental illness like you. So you have better insight as to what the problems are. Okay, the types of LPS conservatorship. Now to the slide. The conservatorship of the person. It's the treating doctor who initiates with the public guardian the conservatorship of the person. You have a conservatorship of the estate. The doctor has nothing to do with that. And the estate does not mean that they have, a mansion and houses and, all this money. They could have court problems. They could have debts coming out their ears, school loans, any of that. That's the conservatorship of the estate. And you can request with the public guardian that you need the conservatorship of the estate so that you can handle these things. Go to Credit Karma and find out what debts they owe and take it from there. If they have a school loan, the school loans can be waived, assuming they do not make more money than the poverty level for the next 3 years, and then it's totally dismissed. So you can get these things taken care of. But remember, it is not the doctor for the estate. You can either, and if you don't get the LPS, of the estate when you're getting it of the person and you find out they have all these debts afterwards, you can go back to the court and you can request the conservatorship of the estate. Now, another thing, and this is just something to remember, If you are choosing to be the conservator at the court, ask the judge to assign you an attorney. Should you have any questions, you can call that attorney and have them answered. And it's a free attorney for you. It's one that will help you along the way as you need it. Okay, next slide. Probate conservatorship, I mentioned that. It's usually older people, but it can be younger people if they have, any sort of like maybe a car accident, so they have brain damage or something. It could be for that. But don't get LPS and probate confused. All right, next slide. The conservatee's loss of rights. Basically, when a conservatee is placed under the LPS conservatorship, they lose the right to refuse medication. That's the essence of your LPS. You hear people say, oh, they take their rights away and they can't even order a cup of coffee without your permission. That's a bunch of bull. The rights that are temporarily terminated are to enter a contract, drive a car, possess a gun. All that can be reinstated while they are under the conservatorship. The goal of the conservatorship is to get them back in society so that they are in recovery and doing well. And we've had people get married under LPS conservatorship, drive a car. We did have one guy get a gun back because he was a security officer and he needed it. And it was more PTS and bipolar that set him off. So that was taken care of. So we did get that right back, but that's very unusual. And I'm sure as all heck not going to ask to have the gun returned for my loved one when he's under a conservatorship. Next slide. The right of the conservator. If you choose to be the conservator, if the public guardian's conservator, that's different. You have the right to approve or disapprove treatment, placement, and medication. And those are powerful tools. Medication is the big one. And there are some really, really good psychiatrists that work really hard with medication to help your loved one to get on the road to recovery. There are too many doctors that write prescriptions and they don't really care. I've heard one doctor say all medications are the same. It doesn't really matter what they're on. It does matter. What medication works for one does not necessarily work for another. So keeping that journal, you have two journals, one everybody you talk to, and the second journal is specifically about your loved one, what they say, what they don't say. Don't correct what they say. If you do, they're going to clam up. And you need to know where their brain is at all times. So don't correct it. Just write it down. What you can say to them is, wow, I don't see it that way. That's got to make you feel very uncomfortable. You can say something like that. That's fine. But once you start saying, that's not true, it didn't happen like that, then that loved one's not going to open up and say anything. And it's very important to know as best you can where their mind is, even in the recovery section. So the medication, you have the right to work directly with the doctor on medication. And if medication isn't good, have a good reason for it. Either it's giving them, putting on weight, Zyprexa. You can blow up to be 300, 400 pounds easily under Zyprexa. There are very few people that don't, but the majority of them do. You want clarity of thinking. That's really important. Placement. If they're putting your loved one in an area that is not appropriate for them, for instance, some IMDs, and that's an Institute for Mental Disease, it's a lockdown treatment facility, and you have to go from lockdown to lockdown, from a lockdown hospital or a lockdown jail to a lockdown IMD. If the hospital says, we'll take them home, we've applied for an IMD, when a bed becomes available, we'll let you know. The moment you take them home, they are not eligible for the IMD because you are not a lockdown facility. So be cautious what the hospitals tell you. But one IMD, they're selling drugs right across on the other side of the fence. The person going to that had a substance abuse problem. That was not going to work. Treatment. If you have a doctor or a therapist or psychologist, whoever it is treating them, and their values are not your values, then you might want to get somebody else. So, you have these rights. If the public guardian is a conservator, they can ask for a medication review, but they cannot tell the doctor, well, I disapprove with that medication, we're not going to do it. And they have to go along with whatever the doctor says. We're going to put them in this place for treatment. They have to go along with it. They're limited. They try to make sure that the person is safe and okay, but they're very limited to what they can do. All right, next slide.
So who should actually be the conservator? Should it be yourself? Should it be the public guardian? Let's take a look at some of the different scenarios that are involved in that. If the public guardian is going to be the conservator, in that whole process of applying for conservatorship, someone from the public guardian office will come to you and ask you if you're willing to be the conservator. And you're thinking, gosh, I don't know what's involved. Well, if it's the public guardian that is handling the conservatorship of your loved one, the pro would be able to place the person in a state-approved facility, and there's less stress for the family member. All the headache is on the conservator's office, the public guardian's office. The negative is that there's less involvement with the recovery process, and there's no control for medication. By yourself, you're not able to step in and say, "Gosh, I think this medication may not be the right medication." You'll not have any access at all. You won't be able to talk to the doctors. All of that, you'll just have to let them handle it. So it takes a lot of weight off of your shoulders. At the same time, you're not going to be involved in the recovery process. So it's very critically important though that if you do, if the public guardian is going to actually be your loved one's guardian, you want to work with them to establish a working relationship. You want to, as much as you can, keep the channels open so that you can provide input to them, make suggestions to them, knowing that they are, bound by privacy laws and can't tell you anything. You do want to nonetheless have a working relationship with them, communicate with them, the history with suggestions on different things that have worked in the past. Next slide. So you think, well, gosh, maybe I should be the conservator. What would be involved with that? Well, for one, you'll have direct contact with the doctor. You'll be able to ask the doctor questions, ask them about different medications, and working with them, you'll be able to have a choice of what medications they can or cannot prescribe. And we'll talk about that a little bit further. Also, in the next pro is that you can reject inappropriate treatment facilities, medications, and treatment places. With all that being said, know this, that let's say there's a medication that you've just never been too fond of, and you don't want your loved one to be on that medication, but lo and behold, the doctors put them on that medication. If you were to approach that doctor and say, gosh, doctor, I don't want on that medication, you might find that doctor taking you to court and taking the conservatorship away from you. So you need to work with the doctor. But, as a conservator, just know that your conservatee is going to try to manipulate you, try to get you to do things that you shouldn't do, ask you for money that you shouldn't give to them, because maybe they're also co-occurring and they want money for their substance abuse. And all that pressure is on you. And believe me, it is a lot of pressure. The other negative is that as the conservator, when your loved one's in the hospital, the hospital's going to try to push you around. They're going to want to discharge the patient to a facility that's not appropriate for their level of treatment needed for their recovery. I've worked with one of our hospitals here in Orange County, and they were moving my conservatee out of their hospital without consulting with me, put him into a facility that was over in another city that I knew was not good. And I had the authority to tell them, no, you're not going to, you need to get him back. So we were able to get him out of that hospital, get our conservative back into a better hospital setting following that. So you do have that right. But again, you're going to find yourself being pushed around by the hospital, and you just may not have an immediate solution. And here they are putting you under a lot of pressure to discharge your loved one. So those are some of the pros and cons of being a conservator. Next slide, please. So the normal LPS process, your loved one is 5150. They're picked up and transported to the hospital. They're there for a 72-hour hold. If they're meeting criteria, then they'll be held for a 14-day hold. Under the 14-day hold, it's critical that they have a court hearing on that. And then following the 14-day hold, there'll be a 30-day hold, or what's called a TCON. So as it says below, after 4 days of the 14-day holding, and Gail mentioned this prior, that a probable cause hearing occurs, which allows the hospital to keep the patient for the 14 days. After the probable cause hearing, the doctor can initiate the LPS with the public guardian's office. Once that's done, then a 30-day hold can be written for a temporary conservatorship. They call that a TCON. And the LPS hearing takes place during the 30-day hold. So that is the process, how things flow. Anything in there, Gail, you want to throw in?
You covered it.
Okay, next slide. So during the court hearing, the patient's assigned a public defender, and the patient can request a court hearing. The judge would hear the case. But then also your loved one can request a jury trial, which is not the best way. You don't want to see a jury trial, because who's to say that the people in that jury may have a bias that they're not being open about, that don't believe in somebody being on a conservatorship. And it's just very, very unpredictable. But guess who gets to make that decision? Your loved one does. So hope that they'll ask the judge to determine whether or not they're going to be held on a LPS conservatorship. Next slide. Gail.
The Mental Health Department A is now located in Norwalk. So if you've been to the courthouse, they moved this about 2-3 years ago, but still some people might have been involved years ago. It's in Norwalk. That's the address. And it's Judge Scott Heron and Judge Rena Gilbertson. They are really, really good judges. I mean, they understand mental illness, and they really help. They do care court, AOT. We're very blessed to have them as judges, because they really do a great job. Next slide. After the LPS is granted, the hospital's what they're supposed to do and what they do are two different things. They're supposed to hold the patient until a proper facility for the patient's care is located and a bed becomes available. They should request intensive care division with Department of Mental Health to come in and evaluate the person for placement. And they evaluate the person. They usually give you like 3 facilities. As a conservator, you can go tour all those facilities. Take a list of questions. Do I have direct contact with the doctor? You're supposed to when you need it. For the most part, you work through the social worker. But if you need to speak with the doctor, you want to be sure you do that. You want to know about their therapy, about their group programs, taking the patient out when they're ready to go out. They're not locked down for the rest of their lives, which I've heard many people say. That's not true. As they recover, you can take them out for lunch. You can take them out to get a haircut, to do whatever. Gradually, some facilities will let you take them home for a night. I will tell you, the first time we dealt with an IMD and they said I could take them out for 4 hours, I took them out. It was returned after 2. Y'all can have them. I don't want them. But after 3 months, he was coming home for 2-3 nights a week, and we hated to take him back because he had recovered that quickly and that well. And that was because of the proper medication. Had an excellent doctor who worked really hard to find the proper medication. We were blessed. The level of care for these facilities, the IMD, that's the Institute for Mental Disease, that's your lockdown treatment facility. They'll go from the hospital to that facility, or from the jail, they could go to a state hospital, Patton or Metropolitan. And there are others they might have to utilize. A step down, which is called an ERH, Enhanced Residential Housing. This is normally, but they can skip. They can go from an IMD to a board and care or an outpatient treatment, sober living, any of those. As to taking the person home, this is just my thought. I would be very cautious about doing that, because it's like when your kid went to college and then they do everything in their college. They wash their own clothes, everything. They come home, dump the dirty clothes, and mom wins dinner. They revert back to the old way. When they come out of a treatment facility, they're being taught how to stand on their own 2 feet. If you take them home, they can revert back. And sometimes it's a good idea to take them home. Sometimes it's not. It just depends on what the situation is. But keep in mind, you're not going to be there forever. So you want them in the system, in a program, and on the road to recovery, so they can surely stand on their own 2 feet. They have sober living programs, and they also have outpatient treatment programs. So it's not one size fits all. You have to figure out where they fit in that program. Next slide. Suggestions for recovery. Remember, if you get an LPS conservatorship, go back to your family album. Remember what that person was like prior to getting sick, and seek that level of recovery. Don't just settle. I've had doctors, the person's on the wrong medications, and the doctors say, well, that's the best you're going to get. They're having delusions, they're hearing things. No, it isn't. What medications are they on? And a lot of people will call me and they'll talk to me. Now, I am not a doctor, a therapist, or anything. I've just done this for a while. My first question is, what medications are they on? And I can even tell you what medications they're on. Probably Cyprexa, Depakote, Haldol, or something like that. They're still having delusions. Up the ante for medications that are good for a person who has a serious mental illness. Invega is a very good one. It doesn't mean it works for everybody. Caplita, Copenphi, Latuda, clozapine. Those really, out of those, chances are you're going to have some pretty good success. And you can also go to ChatGPT. That's capital C, H-A-T, capital G is in good, capital P is in Paul, and T is in Tom. If you haven't downloaded that, download that. That is a really good resource, which when you Google, you get like 50 million websites. ChatGPT crams them all together, and it gives you incredible information. I think you will like it if you haven't used it. And that's a good one to ask about medications for them. Next one. Another thing, take the free family to family class. And I think some are 8 weeks, some are 12 weeks, and some will do it on Zoom, some you do it in person. Great program to take. They have a great class on medications. But you learn so much. You learn how to talk with your loved one, assuming they have reasoning ability. If they're all out in left field, forget that. That is just not going to work. But the program is excellent. That's offered by NAMI. NAMI Urban LA offers the free classes, and they offer these classes, which are free for LPS conservatorship. And tomorrow we have a class that's if your loved one is conserved, What do you do now? What are the laws? What can you do? How can you help them in their recovery? It's a shorter class, but it's a really good class. So if you haven't signed up for that one, I would. Join NAMI. It's a great program. You'll get to know people. They have similar problems to yours, but it will make a difference, and get involved. Now, what Jim and I are offering, and Linda Boyd, Venice, and James Kwon, is all free, but I'm going to charge you. And my charge is to call your legislator and tell them what you need. You need a hospital, serious mental health hospital for each division in the county. And you need these doctors to start initiating LPS conservatorships when it's necessary. It isn't always necessary. And AOT and Care Court have programs that may work better than an LPS conservatorship. You don't know. So that's my deep. How's that? Next slide.
So here's some tips. As you're going along, you need to keep 2 journals. One is for your loved one. The other one is for everybody else that you're speaking with. And keep a sense of humor. So it's very important. I sometimes will initiate phone calls and then later go, didn't write that down. So get in the habit. Again, have something designated as a journal and keep all your notes in there. Keep notes on your loved one's medications, journal on who you've been talking to. But as Gail says, keep a sense of humor, because this will overwhelm you. It really will. And you just have to do what you can, eat well, get lots of good sleep, join NAMI, but a sense of humor definitely is so important to maintain. Next slide. We've all seen these, haven't we? And it's just heartbreaking. This is somebody's family member that's on the street. This may be somebody that's gone lost and you're looking for them. The family's looking for them and don't know where they are. Next slide. More of the same. Next slide. So I am my brother's keeper. Please help us to continue these classes and donate, but only if you're in a position to do so. NAMI Urban Los Angeles goes to an extra expense to put these together. They have a lot of expense just operating every day of the week. And so anything that you can contribute to them would be very appreciative. This is an address. Please, write this down. If you can do a screensaver shot, capture the address. And if that fails, you can go up on the internet. But make a donation, and please state that your donation's for the LPS conservatorship programs, and that will help them out a lot for that. Next slide. Questions?
Okay, we finished early, Jim. We did very good. I'm impressed.
It seems like we missed a slide or something. I don't know.
If we did, I don't know.
I don't remember Outpost for Hope or any of that. I thought that was in this presentation.
I wonder if I sent the wrong set of slides. Could have been.
No.
But no, that's in tomorrow's class.
Yes, if we could do a Q&A at the end when we finish with the slides, since this is being recorded, I just don't want to get any sensitive information out there. Thank you.
Okay.
So I believe next up is Mr. James. I think he's logged in with us.
Yep, I'm right here. Are we gonna proceed with the next set? Great.
Yes.
Thank you. Thank you. So hi, everyone. I guess you get no break, no breathers. We'll go right into this portion. And a lot of it will be a little bit of repeat. So I'm going to just focus on a couple of areas. My name is James Kwon. Once again, I'm the Deputy Director here at the Office of the Public Guardian at the Department of Mental Health. I'm really happy to be here. I think the first thing I want to just start with, if for some reason there are questions that are left unanswered today that pertain to conservatorship or even your journey in this behavioral health world, our info is on here. please don't hesitate to contact us. Usually the Saturday and Sunday nights after these meetings are quite busy because everyone gets a hold of our info and they want to talk about it while it's fresh. And I encourage you to do so. My wife has given me permission to ignore her for the weekend. So, but we want to make sure if you have needs, this is the time to kind of hash them out. So moving right along, let's go on to the third slide. We kind of talked about what conservatorship is. And so, the third slide, meaning the one right before this one. So just want to reiterate here is, there's two sources we can receive an LPS conservatorship application or referral from, right? We can receive it from a hospital that is trained and designated by Los Angeles County to perform those functions, or we can receive it from the court that is hearing a matter regarding someone's ability to stand trial, where a crime has allegedly been committed and a person appears to not be able to present their own defense or assist in their own defense, and all the other programs that they've been referred to through that pathway, like diversion and other programs, have not been worked out. So we are what we like to call the conservator of last resort, meaning really everything else should have been tried before we come to conservatorship, because that will be part of the conversation we have in court. If someone has no mental health history, no attempts at any other programs, no criminal history, nothing, and you show up to court and then they show up, in a suit and tie, again, they can have either a hearing where they agree to the conservatorship, which is not always the case, or they're going to contest it and say, I don't want my rights taken away. I want the judge or jury of my peers to find beyond the reasonable doubt that I am gravely disabled, right? And so in those situations, obviously, it is a much harder case to make. And the public guardian at that point would obviously also think, was this a appropriate referral, right? So one of the things that we like to talk about before we get into the meat and bones about LPS conservatorship is all the programs that I think Jim and Gail kind of alluded to that are kind of the outreach programs and have court components. We talked about AOT, assisted outpatient treatment, care, full service partnerships. AOT and care will be talking about their programs next. Full service partnerships, it's another program within the Department of Mental Health that really outreaches to somebody, right? You're not having to go into an outpatient clinic. You're not going to some private clinic. They'll come out and see your loved one, right? And kind of engage with them. So again, as Gail and Jim also alluded to, sometimes the provider you end up working with needs a little bit of fine tuning with you as the family member to kind of, to get the right mixture of engagement, medications, therapy, all of that. Your mileage may vary depending on the individual that you're working with, whether it be a doctor, psychologist, clinician, whoever it is, outreach worker. But I do want to say that there are plenty of programs before you get to LPS conservatorship. So I just want to kind of put that out there. One of the other things I want to touch on really quickly before we delve into this is, this is not, I'm not a clinician. We have clinicians on the call, but I'm not a clinician. And then also, there's a lot of information out there about both the onset ages for the type of diagnosis that the public guardian sees the most frequently. So if you looked at our database, we have a database so that, of course, we want to make sure all our notes, contacts, all our information about our conservatees are kept safe. If you look at it, the primary diagnosis for 99.9% of our conservatees, who, again, are the most acute of the acute, is schizophrenia or something along that spectrum, right? And a lot of it is, psychotic features, delusional features, that make that person unable to provide for their basic needs. And so one of the other things, just want to kind of put a reminder out is, for those of you who are aware, onset age for schizophrenia for, males is late teens and onwards, right? And kind of, I think Linda and Venus, you guys can correct me, but you see a bulk of the onsets come at the early 20s to mid 20s, right? So the reason I'm saying that is for those of you who have people who are maybe not earlier in that spectrum and you're here kind of preemptively, just want to encourage people to access our DMH programs, as soon as you think is appropriate for someone you may fear is dealing with some of these issues. So I'll get off my soapbox and we'll continue on to the next part, which is about LPS conservatorship. So, as Gail and Jim mentioned, you get hospitalized. Let's say you finally get a call out, someone comes, a mental health team, ambulance, everyone comes, and then they take this person to the hospital. One of the things that I want to kind of clue everyone in on is there's 3 reasons why someone would get put on an initial 5150 hold, right? You can be a danger to yourself, right? Suicidal, danger to others, I guess homicidal, and then gravely disabled. And I'm not quite sure about how many people get held on the grave disability standard on a 5150. Is usually much fewer than someone who is, because danger to self and danger to others is very easy to spot, right? You're wielding a knife at yourself, danger to self. Danger to others would be you're wielding a knife at others, right? How that makes the knife doesn't necessarily make you gravely disabled, right, on the look of it. But as you as the family member will know the history of this person probably not being able to provide for their own food, clothing, or shelter, right? So those are the 3 ways that someone gets put on a 5150 hold. I know that Gail had mentioned, her opinion, right? Maybe not mine, but that sometimes it's very challenging to get to the next hold, which is the 5250 hold, which is the 14-day for intensive treatment. So people come in on the 5150 hold, you have the 72 hours for observation, really, right? You got to triage, figure out what's going on, and then the clinician may say, you know what, this person needs treatment, intensive treatment. We're going to put them on a 5250 hold. The first 2 holds can be done as only danger to self and danger to others. When you're looking at that next 30-day hold, so there's 2 30-day holds that someone actually can be held on, but typically they only get the first one, which is the 5270.15. That requires for someone to be deemed gravely disabled at that hospital. So Gail mentioned they had to have a hospital hearing, a certification hearing, or a probable cause hearing when they're first put on that hold. To succeed to the next level of holds, which is that 30-day hold, they need to have another hearing. Because, this is about people's rights, right? That means that clinician now no longer has a danger to self, danger to others category they can rely on. And if they're going to be held on to that next 30-day hold, there needs to be a case for grave disability. So as Gail and Jim mentioned, this is where that collateral information that the family would most likely have becomes very useful to the hospital, and for you to also make sure that the clinicians and the social workers at the hospital receive all this information, especially if there have been multiple hospitalizations, no ability to stabilize, and that the person upon discharge doesn't really voluntarily accept any kind of follow-up scheduled behavioral health appointments or medication or other treatment. So that's kind of a little bit of a, when you're getting your loved one on that hold, that's why you want to be prepared with that information. Oftentimes this maybe Linda, you can kind of help me on this one, but oftentimes, it's even better if the clinician who is on the scene, who may be writing the hold at the 5150 to make a case for grave disability then, could be a stronger case for a hospital to hold that person through that 14-day hold. So, having that information available really is key early, and to repeat that often to make sure people understand what the situation is. So moving on, as Gail mentioned, a referral to the public guardian office is not like just a script. It's not a piece of paper saying, hey, I think this guy is gravely disabled, right? It's actually a legal declaration, and the clinicians have to put their license number on there. So they're really stating, on a legal declaration that someone is gravely disabled. They put their signature, their license number, everything. So it's not just an opinion, right? It's a legal document with the person's the official diagnosis. This person has a mental health disorder, and they cannot provide for their own food, clothing, or shelter, and they're not willing to get voluntary care. And they've put on a declaration all of that, right? And that's what a referral to the public guardian is when it comes from a hospital. And then they'll put all that information together, chart notes, all of that will come. But obviously, we may not have also that history that you may have given to the hospital. And that's where our investigators will reach out. If there's any collateral information, I mean, we are very fond of finding family or friends that are willing to serve as private conservators. So that's always great for us. Really, the best conservator is someone that knows that person that personally and cares for them in that way. And then, we will invest into that relationship early on by reaching out to them, getting all that collateral information, and then also giving information about the process of the conservatorship process from that point on. The reason why we have to do that and not the general public is by statute, only the public guardian can be the investigator for LPS conservatorships, and we are the only ones that can petition for a conservatorship. What happens is during that petitioning process, if we see that someone is able and willing, we can recommend that particular family member or friend or whoever it might be to be the private conservator, and then they'll be substituted at that hearing if we are appointed on the conservatorship. So moving on, just wanted to, touch on that bottom part of this slide. So I think, we're all very pro mental health. We work for the Department of Mental Health. So, very pro mental health in terms of, doesn't matter how mild or severe it is, mental health should be done just like physical health. If you're not feeling mentally ill, then you see someone to help you with that, just like you would when you don't feel physically well. But one of the things that LPS is not a scheme to get people help as much it was initially a way to make sure that people are not committed to state hospitals without their due process. So I know that there's a lot of frustration with the system. And, I would say the same as Gail to everyone is, you as private citizens live in a country that is built on the rule by private citizens, right? So if there's parts of it that you're thinking, this doesn't work for us as a whole, I would say definitely talk to your congressperson, assembly person, board of soup, whoever it is, to get the laws amended to make that smoother for the greater population. But for now, when it was enacted in 1967, we are going to talk about a huge change that's going to come online in about a month. But since 1967, the purpose of LPS was to make sure that people are not committed without due process to state hospitals. So I just want to take a moment to say, historically, the country has not always been as pro-equality as it has been today in 2025. Some of you are old enough to know that if a husband thought their wife was being neurotic, let's say, in the 30s, they can get a psychiatrist to get, a script for their wife and get her committed to a state hospital without due process. So, if you remember either movies or actual, news from those times, LPS, the reason for it is to make sure people get the help they need, but get that due process. Okay, so moving on, we can skip the involuntary hold part. We can go over to the referrals. So we talked about the hospital referrals. I want to touch a little bit about if your loved one is in a criminal process. I know that Gail and Jim touched on it a little bit, but if your loved one may or may not committed a crime, so let's say something happened and someone gets arrested for something, whether they committed the crime or not is not adjudicated yet, right? And we don't have any judgments about that. But typically, someone who has a mental health illness commits a crime, they're probably not able to assist in their own defense. This is where their attorney, most likely the public defender at that time, would say, hey, there's a doubt as to whether my client can really assist in their own defense. I don't think this person is competent to stand trial, which is fair. It is illegal to try someone for a crime, and they do not have the capacity to be able to assist in their own defense. So when that happens, one of two things usually happens is if the crime is severe enough, they will send that person to the state hospital for a period of no more than 2 years to see if they can get mental health treatment to clear them up to the point where they become competent to stand trial. With the situation that is the LA counties, just, there's a lot of crimes happening, right? So a lot of people are actually being sent, instead of to state hospital or to jail, right? They're going to be sent to what is called a diversion program. So I think Gail touched on that. It's the diversion program is run through the Office of Diversion and Reentry, called ODR. But basically, they also provide, vocational, social, mental health, physical, housing. They provide all these programs in hopes that people get rehabilitated through the diversion program rather than to be tried on a crime that they cannot present their own defense in. So it doesn't presume guilt or innocence, but when people are deemed mentally ill and unable to stand trial, this is one of the pathways that it can go. So where the public guardian's office comes into play is that if they're not able to qualify for that diversion program, if they try the diversion program, but they fail due to the acuity of their mental illness, or they run away from their diversion program, or fail in some other, or not successfully complete the program in any way, typically the diversion program, what they can do is refer it back to the court to say, hey, this guy is not working out in this program. Court, please figure out some other route for this person to go. And at that point, that's one of the focal points where the court can now refer to either the AOT program, care court program, or the Office of the Public Guardian for an LPS investigation. So you do have those three options when it comes to that point. One of the other things is, I know Gail said, you want to try to make a contact in the court, try to have a conversation with either the public defender or anyone else within the trials, criminal settings. Once someone is deemed incompetent to stand trial, they will send that matter over to the Hollywood mental health court. So Gail mentioned Norwalk does LPS and care court and AOT proceedings. However, before all of that, Hollywood is deemed the main center for any cases where the person has mental health issues and thus is not able to stand trial, is incompetent to stand trial. Those get sent over to the Hollywood courts, and the 4 courtrooms there deal with a lot of these matters of should they go to diversion, should they go to state hospital, or should they, since they may have either failed or not have successfully completed diversion or being sent to the state for restoration, they may get referred to our 3 programs that we're presenting on here today. So once we get to that point, then the public guardian will have a referral, and then we will be investigating in the same way that we kind of do for a hospital referral as to whether someone is gravely disabled and how we're going to proceed on those. So both of those, it's the exact same standard, right? It's based on grave disability. I'm gonna move on to, let's talk about grave disability. Let's go to slide 8, because we covered a lot of those and Gail covered a lot of those. So for the sake of time, a little bit after this one more. I want to kind of go over. This is a visual timeline. I added this, and this is my work only, so there might be some mistakes because I am horrible with Visio, but I try my best. This is kind of the pathway of how the involuntary holds work, right? And I added, if you see in that purple, it says penal code PC 1370, 1370.01. Those are the incompetent to stand trial cases where they can get referred to us. So this is a little complex, and I'm not going to try to break it all down, but I do want it to, for you to have it for the sake of kind of like, you know where you're going to be at when your loved one is referred or is put on a hold, or they are in jail waiting competency proceedings, whether, you know, which way they're going to go, right? So once they enter into the LPS system, as you can see from the top, you know, there's always options, pathways out of the system, and then pathways further into the system. So you can see from the top, someone gets put on a 5150 hold. They go to the hospital, and you know they're not so severe where they're like, okay, I got hospitalized. I got to change my life around, right? They actually have the ability. They're not psychotic to the point they're ignoring those thoughts, right? And they're like, I can go voluntary. Like, sign me up for a program. You know, go to outpatient clinic, whatever it is. So in every stage, you have that ability to go voluntary. But as you can see, you know, I've highlighted in green, every time you're going to step up into a next series of holds or something a little bit more lengthier in terms of involuntary holds. So you start with the 5150, the 5250, and we've also put where the person's civil rights can get exercised, right? Within 7 days of being on a hold or 4 days of being put on a 5250 hold, they have to have a hearing. Right. So these are all the things that happen in the background that you as a family member may want to be aware of, so that you know how timely you want to present information to the hospitals, so that they have as the totality of the situation when they are conducting these hearings. Because the other thing is, Gail has mentioned, you know, sometimes hospitals won't hold people based on whatever, you know, again, they're clinicians, they can make their independent judgments. I won't have any commentary about that. However, there are also times where the clinician may want to put the person on the next series of holds, but they cannot provide enough evidence at that certification review hearing to actually get that. Because again, the process of the LPS is to make sure people are not involuntarily committed, even on the short hold, without their due process. So what happens in these situations is the certification review hearing, the clinician at the hospital will bring the case. They will ask the court. The court will actually provide a hearing officer, which appears remotely typically, to show, and then they will schedule a hearing. Everyone will get on Zoom. The person at the hospital will get an advocate. The person who's on a hold will get an advocate, and they're advocated by the Department of Mental Health's Patient Rights Office. Every county is mandated to have one in some form or fashion. That person will advocate for the rights of the individual. The clinician will advocate for continued treatment, and then the hearing officer at the court will decide, is there enough evidence to say, is there enough cause to continue treatment or not? And this kind of repeats itself both at that 14-day certification hearing, but at the 30-day certification hearing as well. Oftentimes, people won't be held on for more treatment even before they get referred to the public guardian, and then they need to have the same type of process. So, I want to put the baseline out there for how rigorous it is to get the next series of holds, meaning, again, kind of like pounding on the point, how important it is for you to be able to provide information to the clinicians about the totality of your loved one's situation, because otherwise they'll be just going based on what they have in their charts, or if they've had any previous hospitalizations within their system. Not every hospital is going to be connected to each other in terms of their the record system, right? So they'll only know what they know unless you provide more. So that one's for your reference. We won't go into it too far in depth. I do want to talk about grave disability, because that is the bar by which we determine whether someone is eligible for LPS conservatorship or not. So let's go on to the next slide. We talked about what is grave disability, and Gail and Jim touched on it a little bit. They included language that is going to begin in like 25 days. So let's table that thought for a little bit because we have it here on the slide, but grave disability is defined currently in 2025 in LA County, at least, is a condition which someone, because of their causation, because of their mental disorder, is unable to provide for their basic personal needs of food, clothing, or shelter. And then, they're not willing to accept help or treatment voluntarily. That's what grave disability is in the code. Just want to say, it is our job as the public guardian to prove that to the court when we are petitioning for a conservatorship. And the level of that proof is beyond a reasonable doubt, right? If you know your legal standards, probable cause is the lowest standard. It's like, I smell something, right? Beyond the reasonable doubt is, oh, that is the entire turkey, right? You have to present evidence where there's no doubt unturned as to someone's grave disability, which is a very high bar. So again, laying the groundwork for some of the frustrations that people have aired to me over the years is like, how come it's so hard, right? And it was kind of intentionally made to be challenging because it's following a little bit of the criminal court aspect of, to determine someone being fully eligible for conservatorship, it needs to be beyond reasonable doubt. With that being said, I think one of the things that everyone has been looking towards is the implementation of what the rest of us know as SB 43. So a few years ago, Senate Bill 43 mandated that the statute change the definition of grave disability. Right? If you're deemed gravely disabled, you can be put on an LPS conservatorship. That's kind of what we've been going on about this whole time. Now they change who is deemed gravely disabled. So as Gail and Jim mentioned, in 2026, so January 1st, 2026, the definition of gravely disabled will be a condition in which a person, as a result of their mental health disorder, a severe substance use disorder, or the combination of both, is as a causative factor for the person being unable to provide for their basic personal needs of food, clothing, shelter, and then now also personal safety or necessary medical care. So let's go on to the next slide. One of the biggest things right there is, this is huge for a lot of people who, Gail, you've been talking about, like some people who have severe substance use, and clinicians kind of like, they hear about substance use and like, well, that person's not eligible for an LPS. People have been looking forward to this being enacted for a while, and it expands the definitions, and it starts January 1st. So one of the things that I do want to touch on in the next slide is, I want to touch on a lot of things, and I'll probably ask for some assistance from our clinicians here, but these are the changes to grave disability. We put these two definitions here for your reference, and I want to be clear. For the previous definition, food, clothing, or shelter is not all, right? You could maybe get food, but if you can't get clothing or shelter, you're deemed gravely disabled. It's not a inclusive, right? It's like one or many, it doesn't matter. And then in the new definition, it will also be the same. If you can't provide for food or clothing or shelter or personal safety or necessary medical care due to either a severe substance use, severe mental health disorder, or a combination of both, you would be deemed gravely disabled. Let's go on to the next slide. This is just a visual. So I just wanted to provide a visual. We've been training people within the county This is just to say, what does the new definition add, right? So as we go on to substance use and use, I think, again, probably more appropriate for Linda or Venus to touch on, but I want to talk about severe substance use really quickly. I've been training a lot with our SAPC partners, that's the county designated agency for providing substance use treatment. We can go to the next slide. So there's a specific definition for substance use where it's considered severe. And it's going to be 6 out of the 11 categories that we're going to see on the slide after this one. We'll go on to the next slide. So these are the 11 substance use criteria, and severe is considered to be 6 or more of these symptoms. And this is not something, I don't have a commentary on this, but I want to manage everyone's expectations in thinking that if your loved one has you feel like they have a substance use disorder, and then now they're going to get LPS, we want to kind of take that and be careful about it, because as you can see, these are the 11 criteria. Now imagine that your loved one has been on a hold for 47 days or more, right? As we discussed, you can have a 3-day hold, a 14-day hold, and 2 30-day holds to get treatment. And that's 77 total days, right? That's a lot of treatment time for substance use where you can't use the substance. So I mentioned before, the standard by which we have to provide someone's gravely disabled, meaning they cannot provide for their food, clothing, shelter, now personal safety and necessary medical care due to, let's say in this situation, a severe substance use disorder. Imagine after 75 plus days of sobriety, how that person's going to present in court. Do you think that your loved one who is very smart and also has a substance use issue, but has been clean now for 2.5 months, will they present well or not? So I kind of want to make sure that we set the, I don't mind presenting. I do not mind getting phone calls about, hey, what's going on? But the reality of it is, with substance use, it is a different nexus than mental health, which is a lot more pervasive in terms of the amount of time needed for treatment to really counteract some of the more acute elements, right? So again, these are the specific categories from the DSM, and you have to be able to say the person is presenting 6 or more of these symptoms. And by the time we get a LPS referral, they'll have been clean and dry for at least 2 weeks. So I just kind of wanted to put that out there to make sure that we manage expectations. If we get a referral and people are still manifesting these symptoms in this way, then we as the public guardian will move forward on clinical advice no matter what, right? But we do want to make sure that we kind of put that out there. Let's go on to the next part, which is, Gail and Jim presented beautifully on the types of facilities that you typically use in LPS. Do not exist in the same way where they focus on substance use disorder. There are, so I don't know if anyone's been to a rehab facility for substance use, but if you have money, then you're going to go to a nice one, right? If you're a movie star, you hear that a lot, right? Like you're a movie or TV star and they go away for a little bit, and then all the tabloid chatter is that they went to rehab, and most likely they didn't go to what looks like a LPS facility. Again, I think Gail and Jim will tell you those are not places where rich people would go to if they had money to spend. So in the same way, they don't have what you would call locked level of care in the SUD system currently. I'm not aware of any locked facilities that do SUD treatment solely, or vice versa, right? SUD treatment facilities that are now locked. The most intensive level of care typically for SUD would be you go to a rehab center and you live there for a period of time. I mean, typically 90 days, right? It's not LPS. Sometimes people will stay in facilities a year, 2 years until they find their stability. But for someone to go to a place to get treatment, like almost at a residential setting, is more rare, and they're not locked. So I do want to kind of put that out there. We put that on here so that people are aware. There's plenty of resources out there, but there's two things. One of them is the facilities don't exist with locked settings, and then the reason that the facilities with locked settings don't exist for SUD care is that historically, from a the efficacy of treatment perspective, people don't do well when you lock them away for SUD treatment. Again, Venus or Linda can correct me, but historically, people do best in voluntary settings where their SUD treatment is being done voluntarily. And obviously, again, a lot of our family will be in a situation where they could have comorbidities, right? So that's a little bit different. But if it's solely severe substance use or any kind of substance use, these are the different settings that people will be getting, meaning most likely you'll be living in a place and then you'll be going somewhere else for treatment, unlike some of those settings that Gail described earlier that our typical LPS people would normally go to. Let's go on to the next other slide. Sorry, I'm taking up a little bit more time because there are a lot of changes due to SB 43. I do want to have people be aware, or at least have the slide deck. So we're talking about in the next slide, there's two new criteria now. So now it's personal safety. And personal safety is a very vague notion, right? Recently, my mother moved in with me after my father passed, and she doesn't like it that I jaywalk to walk my dog. And she thinks I'm risking my personal safety. I would not want to be put on an LPS hold. Just putting that out there, right? And so again, because there's a lot of gray here, we're trying to define it closely, and people have been trained to have it a little bit more aligned with what we're looking for, which is, it's the inability of someone to survive safely in the community without the involuntary detention component, right? And the inability is due to the mental health disorder or the severe SUD or the combination of both. So again, you're on the street, you're a police officer, you're a street outreach team, and you have these observable considerations that you see on this slide. It could be something that triggers that person to say, hey, is this person okay? Now it's been made legal to think about these issues when seeing if that person is gravely disabled or not. So that's what personal safety is. The next slide is talking about necessary medical care. I think the gist of it is basically, if you see something where that person could very much lose life, limb, or a significant function due to their mental health or severe SUD, making them not want to treat that particular thing. Sorry, if you click forward, there'll be more. That is what the grave disability criteria for necessary medical care is. If you see me eating a Snickers bar and you're like, sugar is bad for you, don't put me on a hold, right? But if I've gone to the point where, because of my delusions, I'm eating only, I can get food, right? But I'm only eating 4 peanuts a day. And the voices in my head say, if you eat 5 peanuts, you'll die. If you eat 3 peanuts, you'll die. You can only eat 4. And I'm malnourished to the point where it causes other medical issues as well. That can be a reason to put someone on a hold. There's probably going to be a lot of questions regarding this, so we'll take them at the end. But these are the two new definitions of grave disability, and then one of the criteria that got expanded again is someone can be deemed gravely disabled if they have only a severe substance use disorder. Let's move on to the next slides. I want to finish quickly. Again, Gail and Jim went over all the powers. But again, if you're looking for an LPS, you're looking to do two things, like they said, right? You want to put them somewhere safe, and you want them to get treatment. None of the other restrictions and stuff, Gail, I agree with you. That can be regulated, but in terms of, that person will lose their ability to decide where they get to live, and get treatment and get the type of treatment. However, I do want to say, obviously, when we're talking about the most either psychotic or diluted, state that our loved one can be in, maybe getting their feedback on what type of treatment may not make sense to you. But as soon as their capacity allows, incorporating them into the care plan as much as possible is, something that you want to think about, where I think as a private conservator, it might be harder for families where you're not sure if you're being manipulated or not, right? We as the public guardian, I think, Jim and Gail made a great point. Like, we don't get manipulated because we don't have the same feelings for your loved one as you do, right? We care about our public service duties, but we don't have that history with them. But that being said, I think in terms of treatment plan, and then again, I think, Gail, your story about being a little bit iffy at that first home visit or first outing, totally understandable. That's the most frequent story I hear, is like, that first time didn't go as well as I thought, or, it's like, I didn't want that full time. And then soon your loved one will be at the point where, maybe they can come and stay for a weekend. And I think being open to these situations and knowing that as a private conservator, at least, you guys will have some of those flexibilities, I think is important to know during the process. So again, treatment and placement, really the only thing that you really exercise powers over that are going to be consistent. What I want to touch on, one other thing is, I think people get sometimes a misunderstanding of being forced into treatment. What that is if you're treatment resistant, meaning you don't want to go to anything, you don't want to do anything, you don't want to take your meds, there's not a giant person that makes them swallow medications or drags them to groups, right? Like, that doesn't happen. A lot of it is through social engagement at these facilities, right? And some carrot and some stick, right? The stick being, hey, the more you participate, the sooner you're going to get out. Like, everybody wants that. No one's like, hey, I want to stay in this IMD forever, right? And then the carrot is definitely just, there are little incentives here and there that people can earn to make sure that, they're incentivized to participate in programs, rehab, vocational, social, and then of course take their medications. So just want to make sure, like, no conservator, you're thinking, well, as soon as I'm the conservator, we'll hold them down and give them some meds. That does not happen, and that would, betray some rights of that person. And then of course there's the other part where a lot of the treatment is done through injections as well. So I think those are things that, again, talk to the provider, talk about, titrating off or on, getting the right, really, I don't want to say cocktail, but, combination of medications that can help stabilize your loved one. Moving to the next slides, again, I want to just touch on the estate issue. Most private conservators do not become the conservator of the estate. They will become the representative payee, though, for the person's Social Security benefits, because you want to be the one controlling that to make sure the facility gets paid what you call the bed rate, right? Medi-Cal or the mental health plan may pay for the treatment part, the behavioral health part, right? But they don't pay for necessarily the bed and the board, which is like the bed and the food. And that is usually done through what Gail and Jim described as a SSI, SSDI if you do have the credits. But we would recommend typically that the court appoint the private conservator, the conservator, the person only, and then the estate powers really are not needed, and you guys would just become the representative payee, meaning you become responsible for the Social Security payment being received and then paid directly to the facility as appropriate. We can skip over the restrictions, but it's there just for your perusal. Let's skip 2 slides. So Again, I'm going to just go over this quickly because Gail and Jim touched on this. Also, you can always reach out to our office because if you do get the conservatorship as the private conservator, you'll already have worked with one of our staff because they'll have done the investigation. They'll have vetted you as an appropriate private conservator, and they will have petitioned the court to appoint you as the private conservator. Sorry, one more slide, please. So you can always kind of call back to rely on them for next steps. But what should happen is the person needs to get put into the appropriate placement, right? They can't stay in the hospital forever. Nobody wants to do that. What typically will happen is if the person is on Medi-Cal, the mental health plan, which is DMH, a part of DMH called, so Gail, I think the name change is no longer intensive care division. They call it bed management. Same job, which is to find the right clinical placement for your loved one. So the clinicians at the hospital and the clinicians within the bed management group will collaborate to see, the acuity of the person and what kind of facility could best serve that person. And then they will suggest the proper level of care. I agree with everything Gail is saying. No facility is created equal, right? Just like no Taco Bell is created equal either. Some make great Taco Bell food and some don't. It's just the way it is. So again, without making any commentary on it, I would suggest heavily that as you're working with bed management, take the tour, talk to the staff. I think just like you would have with their teachers at a school, getting a relationship with the facility that either you choose or sometimes there's just only one available. These are publicly funded options, right? There may not be another opening and you may not want to keep your loved one in the hospital waiting for the right one. So, but I would say get involved with the clinical team heavily, help them to be educated on your loved one's history, as well as, you can get education about what they provide and, maybe things that they don't provide that you may need to figure out how to get additional supports for. And then again, this one, once they're in a facility, then, you talk to them regularly about how they're doing, and up until your 1-year renewal, then either they'll be coming home to you guys with passes or doing outings with you, or, sometimes it takes longer for that turnaround. And I think, that's also another bar I kind of want to set, again, not a clinician, but typically I like to say, in the worst case scenario, sometimes it is like a 1-to-1 in terms of the amount of time you spent acute being not treated is the amount of time you may need for recovery and stability. And, I'm not saying that to bum out anybody on the call, but I do want to make sure that it's okay if it takes a little longer for your loved one to reconstitute and be themselves. It's like that with any other ailment, right? It could be like that with physical ailments. So I do want to make sure that, you guys can find hope and joy in the small little wins and not be too discouraged in that it may take longer. And sometimes it may take longer than that 1 year. And then you'll have to get reappointed, right? Because your loved one will still be greatly disabled. We'll go on to the next slide. And, this is more a conversation for tomorrow's group, but LPS conservatorships are renewed every year. I think that was described. Things don't change in terms of the bar to get renewed for an LPS conservatorship as it is for getting it initially, in terms of it still requires a doctor to sign, on a declaration. This is a legal document where the doctor is signing, putting their license stating, I declare this person is gravely disabled, right? And the court has to make the same ruling, either at the reappointment hearing, the conservatee will say, you know what, you're right, I do need it. I don't contest, or they're going to say, heck no, I'm going to contest. And it's going to be the same situation as at the appointment, where they could set a hearing, court trial date, they could set a jury trial date, and then it is up to you now as the private conservator, working with your attorney and the doctor at the clinical team at the facility that you're at, to prove beyond a great reasonable doubt that your person is able to not function and is gravely disabled. I think that's it. I realize my contact is not in this slide. Our office's contact is. So I think, I don't know, Gail, if you have a distribution list for the callers today, but you have my email. I think email is the best way to reach me because otherwise my secretary will screen my call. And she is good at what she does. So, because I'll be in meetings most days, almost every day. So email is best. I try to respond within the same day if possible.
Thank you. That was excellent. I appreciate it very, very much. I do have a quick question. ICD, you said now it's called bed management?
Yes.
Okay.
Same job, nothing's really changed.
Okay, same number.
Yeah.
Okay, sounds good. Okay, Linda?
Good afternoon. So James is such a tough act to follow. And I have to give you a shout out, James, not only for the presentation, but of your really cool sweater. It was really a cool sweater. Just a couple of comments to add to what James was saying. First, Gail, Connie Draxler has had the luxury of retiring.
Oh,
So
I
now,
didn't know that.
so James is now the guru of public guardians and all the information. As you can tell, super knowledgeable, all the information,
Yes,
anything to do with public guardian's office. In terms of the substance abuse only, to James's point, there is no locked facility in the state of California. And I think the philosophy behind it, as he spoke about, is that for folks who are treating substance abuse, they really feel like unless the person wants it themselves, that it won't be successful, which is why they've not had involuntary drug treatment. And I think we'll just have to see long-term how it plays out with the changes with SB 43. I was thinking about in terms of medication in Power 8A, and I say this to people all the time, that particularly for all of you, you'll have the authority to medicate and not always the ability, because if you're a 5'5" mom and you have a 6'10" son who has a mental illness, is on a conservatorship and says, Mom, I'm not taking my meds, you have the authority, but getting that person to voluntarily accept that medication, because to James's point, no one is going to hold that person down. So I think that's always sort of kind of a struggle, because we say you can get your loved one medicated, but it's not always, and you all know that it's not always as easy as it sounds in the beginning. And I was thinking about the safety piece of it and personal safety. And the way I think about it is, if someone has a brain tumor, well, let's say no, if someone has cancer, they have stage 4 cancer, and they say, I don't want to get chemotherapy or any kind of treatment. And I understand and I know that if I don't get this treatment, that I am going to die. But I also know chemo can make me very sick. So I want to live the quality of life that I have now for as long as I can. That person is not gravely disabled. That person is able to make a very rational, conscious decision about how they want, understanding all the ramifications, how they want to live their life. What often happens is, and we see folks with cellulitis, with the open wounds that James's slide referred to, we see lots and lots of swelling of lower extremities. And, the person is just oblivious to that medical issue, or, God will heal it. I've heard, if I stay in the sun all the time, it will be taken care of. That's when we start thinking about the person is unable to take care of their medical needs due to their mental illness. So I don't know if that helps sort of differentiate the difference, because we all, when we're out there evaluating folks, are going to need to evaluate the difference. And when someone's running in and out of, James, if we see you jaywalking with your dogs, I promise we won't 5150 you. However, if you're running in and out of traffic all the time because you're so preoccupied with your thoughts, the delusions, the hallucinations, the voices talking to you, those are the kinds of things for which the person doesn't have any regard for their personal safety. And we see that. We see that often. And so those are just some examples, and there's a myriad of others, but I don't know if that helps folks, because it is going to be a little difficult in the beginning, especially I think for all of us to differentiate what's happening and the intent and the cause behind it. So with that, let me start and talk some about care accord, and some of the other things that James talked about will be incorporated into this as well. So care accord was put forward by Governor Newsom, and he touted it as a way to give assistance to homeless folks who have a mental illness. It is not just for folks who are homeless. And in fact, Care Court starts with a petition, and we'll talk about that. And over 2/3 of the petitions that we've gotten in LA County so far are from family members. So this is one of the only programs that I know about in the Department of Mental Health where a court order for treatment begins with the family, or can begin with the family. With AOT, as Venus will talk about, are referrals made by the family. It can be made by the family. Then they do the outreach and engagement, and then the Department of Mental Health files that petition. If it's a conservatorship, they're in the hospital, or the home team goes out to see the person. They spend time trying to provide treatment and then deem the person gravely disabled, even in jail. And then the Department of Mental Health or the Department of Health Services or the hospitals file petition for treatment. Even in criminal court, a doubt is declared, a crime's committed, a doubt's declared, then they go to Hollywood court and an examination happens. Care court is the one place where the family can petition the court directly for mental health treatment. Next slide, please. CARE stands for Community Assistance, Recovery, and Empowerment Act. And what it does is every single county in California must have a care court program. Some call it, the legislation that created it is called the CARE Act. So some counties call it the CARE Act, some counties call it the Care Court. We call it Care Court in LA County, but we talk about our care teams. So we don't always use court in our verbiage. And we realize that for many of our folks, court has a very negative connotation because many of them have been in criminal court and their experience has not been a positive experience. So a lot of the counties aren't using the word court in the process. It provides housing, case management, therapy, medication, whatever that client needs. The client does not have to have been incarcerated in order to be a part of care court. And then let's go to the next slide because I think it'll explain more about, and you can just hit them all, Arsene. So this is the criteria by statute that makes a person eligible for care. They must be 18 years or older, so it's for an adult, and they're diagnosed with schizophrenia or another psychotic disorder. And so that is schizophrenia, schizophreniform, schizotypal personality disorder, unspecified psychosis. And as of January 1st, there's been new legislation, and the diagnostic criteria will be expanded to include bipolar disorder with psychotic features, which I think is mainly bipolar 1 and tends to happen when folks are manic and they have those delusions of grandiosity, they're God or they own mansions or they're the government. And so that criteria begins as of January 1st. Although the judges have been accepting petitions with that diagnosis almost since our inception. The client is not clinically stabilized at ongoing treatment. So they may be seeing a private psychiatrist and not taking meds. They may be involved in one of our department's full service partnerships and they may see a case manager, but they're still just not doing well. They're very symptomatic. Their condition is worsening. So even though they are in treatment, they are still eligible for care court. They have to be substantially deteriorating. And I know that can sometimes be difficult. Sometimes for your loved one, they sort of stay in their room and they eat and they sleep and they shower. So that doesn't mean, and they're accepting of your care and what you're offering to them in terms of food, clothing, and shelter. They don't meet grave disability criteria. And they're isolated, but they're sort of staying the same all the time. If they begin to not communicate with you as much, isolate more, their behavior is getting a little worse, their symptoms are getting a little worse, that's the time to petition for care. The person's unlikely to live safely in the community without support, or the person was doing well, and we use this criteria often for folks who are stepping down from conservatorship. So they're no longer gravely disabled, but they still need a safety net. They need some treatment, but they also need some oversight. And so it's to prevent relapse and deterioration. So participating in care must be the least restrictive setting for that person in order to help with that person's well-being. And the person must be likely to benefit from the care program, which sometimes it creates some difficulty because someone really may be gravely disabled and need a higher level of care. And so our program would not be the least restricted for what they need, and they would not be likely to benefit from our program. Next slide, please. So the two things that I'm not sure, it should be here somewhere, but I want to make sure that, so even though we have a court component, and this sounds like an oxymoron, and I always feel like it's an oxymoron. So care court has a court component. We do see a judge in Norwalk Court, 2 judges in Norwalk Court, and the petition goes to the courthouse and the judge determines that it meets care criteria, then sends it to the Department of Mental Health. So the whole thing starts with a court process. Given that, it is still 100% voluntary. So we cannot order medication. Both of the judges, Judge Gilbertson, Renee Gilbertson, is very soft, and she's a very soft and kind and gentle female judge. Judge Heron is a little more, I wouldn't call him soft, but I would say that for both judges, the thing that's critically important is they are very, very, very client-centered. Their focus is on the client. How can we help you? What do you need? What can the team provide for you? What's going well? What's not going well? The whole court process is extremely collaborative. So the attorneys representing the clients, who for care court are ITCO attorneys, independent defense counsel attorneys. Those are attorneys who are private attorneys who have signed on. They're under the auspices of the public defender, but they are private attorneys who have signed on to be part of a panel who have agreed to take care court cases. So those attorneys represent your loved ones, or what we call respondents in care court. They represent the respondents. County counsel represents the Department of Mental Health. So these are the folks who by law can petition for care court. So of course, all of you, a person with whom the respondent resides, so that could be a roommate who's over the age of 18. It doesn't have to be a relative, but a spouse, a parent, sibling, child, grandchild, anyone who acts in the place of a parent. So if you're the cousin of someone who has a mental illness and you're the person who spends the time and cares for that person and stays in touch with that person, you can petition. It's the definition of family is very expanded in care, where it's a little more restrictive in AOT, as you will hear. Or the respondent, the client themselves. And we've had about 10 clients who have petitioned themselves. By and large, if someone knows they need treatment and they know they need treatment enough to petition the court for treatment, we generally refer those folks to an FSP, because if they're willing to get treatment, they don't really need care court. And there have been two exceptions to that, two exceptions where a home client has said they wanted care, and we've coordinated with the home staff who said, this person's not really compliant, please accept them. They're willing to apply themselves, and so we accepted those folks into care. But for the most part, if a client knows they need treatment and is asking for treatment, they don't need this level of care. They won't need the court involvement. First responders, peace officers, paramedics, firefighters, homeless outreach teams can also refer. The director of a hospital or their designee. So we get a lot of LPS hospitals who are referring. We get medical facilities where folks are often coming into the emergency room with mental health issues, not necessarily medical issues. Licensed behavioral health professionals, and the anybody who has a board and care or any kind of place where the clients are living, they can also apply. In terms of the county DMH themselves, we do referrals to care court. Public guardian, as I mentioned, is a step down from conservatorship, or they need to look at other resources before they file the TCON. So they often look at AOT and care. Is that a reasonable alternative to conservatorship? And the director of adult protective services. And this is the first program I know of where someone from adult protective services can petition for mental health treatment. Also, the director of a Indian Health Services program and the judge of a tribal court or their designee can file for care. Next slide, please. So just, I'll go through this quickly, but once you file a petition, the judge determines whether or not it meets care criteria. Excuse me, the judges in LA County have been putting everything through, so they've not necessarily stuck to the diagnostic criteria. They were very much wanting everyone who possibly can get help to get help. So they're not rejecting many petitions at all. We celebrated our second anniversary December 1st, and we've had over 600 petitions so far in LA County. Once that petition happens, the judge determines it meets criteria. They send it over to the Department of Mental Health, and our care team begins outreaching immediately. Then we will do, we must complete a report to the court that says, yes, we believe this person meets care criteria, and it goes through all the diagnosis, how they're deteriorating. And then we start working with the client. We start working from the time we get that petition, we start outreaching to the client. And as a part of that, we develop a treatment plan. And that involves usually medication, therapy, case management, and then whatever other services that person needs, whether it's to get them on SSI, or SSDI, whether they need food stamps, if they need substance abuse treatment, whatever that client needs, and whatever goals the client has. Often our clients want to be able to get to the point where they can go back to school or get to the point where they can get a job. And we know sometimes when we put that in the care, in the treatment plan, which we call a care agreement, families are saying, my loved one is nowhere near ready to get a job. And we know that and we understand that, but that's the respondent's goal. And so we want to help them get to that goal. So we'll do whatever we can to make that happen. Sorry, excuse me. So once we've developed this treatment plan, the client signs it, and we do that in conjunction with the client. The client signs it or the respondent signs it. Their attorney signs it, we sign it, our attorney signs it, and the judge signs it. And the judge can add whatever they want to the treatment plan. They may decide there's some other things. We've had judges order bicycles. We've had judges order different things that the client wanted and needed. And that's added to the care agreement. Once that agreement is signed by the judge, the care program goes on for 12 months. So we may be outreaching to that client for several months before we get to the point where the client wants that care agreement, that care plan. If the client refuses to meet with us, if the client refuses the care agreement, then it turns into a care plan and the judge still orders it. The client doesn't agree to it, but the judge still orders that plan. And then there are progress reports to present to the judge, and the client appears. And the client can either appear on WebEx, which is now called virtually, which is now on Court Connect, or we will facilitate the client getting into the court if they want to appear in person. So if the client's willing to come with us, our teams will pick them up and bring them to court. If the client wants to come to court, but they may not be quite so safe for us to drive, we will use a taxi to get them there. But we will get them to court if they do want to appear in person. If they want to appear virtually, we will go to their house with our laptops and get them on so that they participate in the hearings. And again, that happens with Care Court that doesn't happen in other programs is that the respondent gets to choose someone, if they wish, to participate in every aspect of the treatment that they want someone to participate with. So it may be the person who petitioned them, it may be a close friend, it may be another relative, and just as in the conservatorship, the judge vets that person. So their drug dealer can't be their supporter, right? So, and this person has access to helping establish the treatment plan and is involved in as much of the treatment as the respondent wants them to be. So, and they advocate, that supporter advocates for the client and advocates for what the client needs. At the 11th month, we present to the court our plan of what happens next. And one of three things can happen next. Either the client will graduate from the program at the 12th month, or the client can decide that they really are feeling supported and want to stay in the program for another 12 months. Or the client is not doing well and hasn't met their goals, and we feel like the client should stay for an additional 12 months. So the maximum time they can stay in the Care Court program is 2 years. But it is in 12-month increments. And for those who decide they want to stay, suppose for this in the second year, after the 3 months they're doing so well, they say, you know, I don't think I need to be in court anymore. Then it ends at that 3 months. It doesn't have to go the whole 12 months for the second year. Next slide, please. So the other two criteria that are associated with care, and we don't talk about this a huge amount because well, I'll tell you in a minute. So one of the things that the other criteria should be that the person has had 2 5250s or 14-day holds, or what they're considering intensive treatment in a hospital, the last one being within the last 60 days. So for a lot of families or a lot of even first responders, they may not know if someone has been in a hospital on a 5250. And so the other thing that can happen is that there is a declaration from a mental health provider who says, I have evaluated or I have attempted to evaluate this person within the last 60 days. And we know for a lot of you that, you know, your loved one has refused mental health treatment and may not have seen a psychiatrist in a year and may have been hospitalized once. Do not worry about that, because once we get the petition, we will go out, we will do the evaluation, and we will fill out the paperwork that the mental health professional needs to fill out. So for you, the only form you need to fill out is what is called the Care 100. And if you go to lacourt.org care, this petition Care 100 will pop up. And it's going to ask you a series of questions about the diagnosis of your loved one, the behavior, all of the criteria that I mentioned a few slides ago. What are their behaviors? What are their symptoms? How are they not doing well? Why do you think they need supervision? Do you think the care court program is appropriate for them? Do you think they will benefit from them? Once you, and this is all fillable online. Next slide, please. Once you have filled out, oh, okay, it'll be after this slide. Once you have filled that out, you can e-file that form. And when we get to the next slide, it will show you how to do that. The other thing that you can do is that most courthouses in California, but in LA County, there are self-help centers. And those self-help centers are located in the 11 courthouses that are listed here that have family law. In the Norwalk courthouse, where CARE, AOT, and LPS, where those hearings are held, the Norwalk Self-Help Center is just for folks filing care petitions. And housed at that self-help center are DMH employees. So if you have questions, if you have concerns, if you have need resources, we have DMH that staff that self-help center all the times that the self-help center is open. So it's Monday through Thursday, 8:30 to 12 and 1:30 to 4:30. On Fridays, they're open 8:30 to noon. The other courthouses have they have kiosks where they have a virtual connection to the Norwalk courthouse so that you can go to your local courthouse and go to that kiosk and connect with the DMH staff who can assist you with filling out the form and also help you with any resources that we have in the Department of Mental Health that will help you and your loved one, including referrals to NAMI and resources for NAMI. This also is the Self-Help Center phone number, and there's lots of choices. So you press 8 to get to the information about Care Court. On the initial sheet that you showed at the beginning of this presentation, my number is wrong. So I've put my correct number in the chat, and it is my cell. It is good, to James's point, it is good 24/7. So you are able to reach out to me. Next slide, please. And then it just talks about, next slide, please. Next. So, next slide, please. So this is the e-filing for lacourt.org. Some of the petitioners have had some difficulty. There have been some glitches with the e-filing. If you have, and when you go on to the 101, it will tell you how to e-file. There is no charge for you to e-file. For attorneys and for other charges in other courts, there is a filing fee. But for Care Court, there is no filing fee. So if you find a glitch or you're having some difficulty, reach out to me. And also my email is, and I can put it in the chat, lboyd@dmh.lacounty.gov. So I can put that in the chat, but you can reach out to me by phone or email with questions and concerns. But then I also have my staff who are at the Self-Help Center assist with filing these petitions. The other thing that I think it's important to remember is that for our full service partnerships for AOT, private insurances often do not pay. And so Medi-Cal, for our outpatient services, Medi-Cal does pay for all of the services that the Department of Mental Health offers. The legislation, in their wisdom, in the CARE Act, incorporated that once the judge signs off on that treatment, that care agreement or that care plan, basically that treatment plan, once the judge signs off, that private insurance, commercial insurance, must pay for any of the services that the judge has signed off on. So the law orders private insurance to pay for the Department of Mental Health's treatment of their insured. That is not true for any of the other programs in DMH. They often will pay for the crisis for our PMRT services, but they will not pay for full service partnerships. They will not pay for outpatient treatment. And the share of costs can be prohibitive for families and for our clients. And so Medi-Cal for Department of Mental Health Services is the insurance that does pay for everything that the department has to offer. So I thought they would add that. Also, when we're looking at the client's history, when we're writing out the reports for the care to give to the judge to say, yes, we agree this person meets criteria. If a client has been hospitalized and they have Medicare or private insurance, none of that information shows up on our electronic records. And then we will go out, we're seeing the client anyway, we will write the CARE Act 100. And now there's another CARE Act that we can, petition 102 that we can write. But for you, the petition 100 is for family members and other folks to refer. Again, don't worry. If the person, I was going to say the diagnosis, but the schizophrenia spectrum and the bipolar disorder diagnosis is now included. And our judges are putting everything through at this point. Next slide, please. I'm seeing if I believe that, next slide. And so court can be attended, as I said, in person or virtually. And we've talked about the ITCO attorneys. Next slide, please. And then just if you can reach out to me at our website, which is carecourt@dmh.lacounty.gov. And I think Venus put that in the chat, or my cell or my email. And then I'll be happy to answer any questions at the end of our presentation. So with that, let me hand it off to Venus.
Thank you, Linda. So first of all, I think it's kind of difficult to present after James and Linda wonderful presentation. And especially I love James, the personal example about the jaywalk, the peanut, and then Linda talk about Judge Heron and Gilbertson. And Judge Heron of the AOT court, he's different, but he's really can be very passionate and have a lot of wisdom. Especially I see him how to talk to individual who really have difficulty to engage in treatment. There's a lot of wisdom, a very good balance of compassion and how to engage the individual. So next slide, please. So I think, of course, Linda talked about the history of the care court. For AOT, I have to mention about Laura Wilcox. I mean, this lady, 19 years old, in 2001, she was volunteer in an outpatient clinic during the winter break. But unfortunately, she was killed by individual who suffered by severe mental illness, who declined mental health treatment. Because of that, 2002, there's an assistant outpatient treatment demonstrate project, also known as Laura's Law, established. And AOT-LA is implemented in Department of Mental Health, DMH, in 2015, and the past May, so AOT has been in LA County for 10 years. Next slide, please. AOT, we can say, this is a balance. They allow the county for those people, for individuals who have severe mental illness, who have a history of treatment non-compliant. Just like Gail say, you are sick, I'm not sick, you should be hospitalized, not me. continue to deteriorate, poor psychiatric compliance. But guess what? They have a risk to themselves, to the others, don't want any voluntary treatment. So the main goal of AOT is to hopefully engage them, and hopefully individual will be voluntary to treatment. And there's two modalities. One is called Full Service Partnership, aka FSP. It's a field-based wraparound program. Instead of individual have to go to the clinic, the program, the treatment provider go to them, and they have a whole array of service like medication. They have some substance abuse. They have case management. Some even have occupational, link them to find a job and study. So they try to wrap around the individual. On the other hand, another service AOT can usually link individual is called enriched residential services, also aka ERS. Even though we say residential services, but it's not inpatient. It just have an outpatient, a housing component, as also a intensive mental treatment. And in LA County, AOT, this FSP or ERS program is not directly operated by Department of Mental Health. It's contracted to the provider. But those providers in the past year has been worked closely with AOT, and they have a lot of experience in particular serving the AOT FSP client. Next slide, please. Of course, we talk about, AOT have an option to petition individual to the court. And this is something that is a little bit different from care court. Linda mentioned they start with petition, but AOT start with referral and petition. So I'm going to go more into it. And AOT programs basically is using a interagency collaboration between the court, the county council, public defender, the ECHO attorney, patient right, and local and law enforcement. And we do have a lot of established relationship with the law enforcement which I'm going to talk more about. Next slide, please. AOT eligibility criteria here are listed down 7 points. It's based on the Welfare Institution Code 5346A. And a lot of this is very similar to care court. For example, number 1, 18 years age or older. Number 7, have to be likely to benefit. Number 6, AOT have to be least restrictive. These are the same as the care court. So I'm going to elaborate individually about AOT in this situation. Number 2, about the serious mental illness. Of course, care court, Linda mentioned about they have to be schizophrenia, spectrum disorder, or bipolar 1 starting the January 2026. AOT pretty much all the serious mental disorder, including depression, or including we have people who have PTSD, but have to be treatable, not something related to if it's just a long, for example, dementia or a long traumatic brain injury. It can be called dual diagnosis, but cannot be something that we can't really through mental health treatment to treat. The number 3, I think about clinical determination that treatment history and current behavior have to be number 1. Bullet point number 1 is substantially deteriorating. It can be someone that have recent acts, threat, or attempt to harm self or others. Recently have some site hospitalization, worse than baseline. Unable to maintain housing, daily functioning, get arrested. There's police call. There's a restraining order. Neighbors have been calling police and complaining at risk of being evicted. It's just that at the baseline, it has been deteriorating. And of course, AOT try to prevent relapse or deterioration that may lead to grave disability or harm to self and others. One of the things I want to spend, one of the criteria I want to spend a little bit more time to elaborate is number 4. We usually call this objective criteria, because for some of the bullet point number 3, 5, 6, and 7, sometimes we still have a little bit up to interpretation. We have to base on the record and we have to discuss. But number 4 is pretty much objective. Either you have it or you don't have it. And based on the, we call it based on the history of non-compliant and result in one of the following. Then number 1 point is about the individual have 2 or more hospitalization. Here we talk about site hospitalization. not medical, and or forensic mental health episode. That means the individual is not only in jail but receiving mental health treatment in the jail, can be in the prison or jail, stay or local in the past 36 months. Or individual had one or more acts or serious and violent behaviors towards self and others. Here we talk about a serious violent behavior. It not only about a gentle push on the arm, a kick you in the leg. We have to talk about the context. For example, individual, the victim, is a healthy 20-year-old young adult, or it's a push towards an 80 years old fell grandmother to the floor, and it's different. And then what is the trigger? What is the situation, the context, the consequence? Is there any police call? Is there any medical treatment need? Is there any abuse report file? And so all this, we have to consider the context, and also includes threat and attempt to cause serious physical harm to self or others. And this particular criteria have a longer allowable time, is 48 months. But for this particular criteria, sometimes we say act of violence. Because if AOT finally have to move towards petition, and in the court, we cannot take hearsay. So the individual who is the victim or the person who witnessed this act of violence have to be go to the court finally petition to testify. So I think we have situation that in the housing program, the individual maybe being the victim, they refuse to testify, or the housing staff witness it has already left the program. So in this situation, it won't work. But I think if you have a situation like this, I always recommend to consult, and you will always find my email or the AOT general email that you can consult about the situation. For example, we have recently we have the individual, the sister witnessed that the individual pushed the elderly mother to the floor, punched her, resulting in a elderly abuse report, and he also resulted in being in the jail. And the sister come to the court and testify about this act of violence. And individual family have restraining order, but they really scared of the individual. They have to move out of the house. But individual, still take over the house. He cannot hospitalize him because he barricade himself inside the house. But this act of violence by itself, because the family is able to testify, then finally individual go through a lot that I'm able to hospitalize, petition. We finally link the treatment, and a couple of weeks ago, I see him through the LA Court Connect. I see him just really totally different. Now he's receiving treatment. So I just want to say this is important, one of the elements of the AOT criteria. And on the end about the number 5, also different from care code, that have the care code allowed to be individual be linked to treatment, maybe in the FSP or outpatient, but just not clinically stabilized. In AOT, we have the individual have to be failed to engage in treatment. That means if individual, they may be seeing therapy, they may be seeing a psychiatrist, but they refuse to take medication. AOT is voluntary. We can't force anyone to medication, just like James say, somebody who is big, you can't just force to throw a pill down the throat. So if individual is really in treatment, AOT cannot accept individual to AOT. So, but of course, there's time the individual is really say they are in therapy, but really not meaningfully engaged, really talk about something like the weather, really see 5 minutes and then not really engaging, then we'll have a chance that you can consult me, call me up, email me, then we can talk about individual case, whether this individual will be able to be accepted to AOT. And of course, we will also talk about whether individual will be able to benefit from the AOT treatment. Number 6, we talk about AOT had to be the least restrictive. If individual is already participating in outpatient or FSP level of care, and individual is really able to appropriate that level of care, so AOT won't be able to accept. And Lyndon and I, we talk on a regular basis, Some individual may be more appropriate for AOT, the presentation. Some may be more appropriate for care due to the diagnosis or the presentation and the insurance status. And there's a time that even care will refer to AOT because individual may need a higher level of care, may need the AOT. So just want to say that we try to find what's the right match for individual. Next slide, please. And also here, talk about AOT qualifying referral party. And here we see that it's also referred to institution code 5346B3. You can see that most of the criteria, most of the referral party here are also qualifying referral party for care court or petitioner. But one thing is that AOT is more limited. And in this presentation, I'm going to focus more on just A, B, and C. For A and B, maybe for you who is in this presentation, you are the one who living with individual or you are the family member. But I think it's, for those, I'm going the next slide, future slide, I also talk about if you are not the one who living with them, for example, you're the cousin, you're the nephew, you are the auntie, so what can you do? I think moving forward, I will show a slide how you can also refer your individual, that your loved one, who is not living with you, but you are not the parent, you are not the sibling, a spouse, or adult child, how can you refer the individual to AOT? So number C is also like, we talk about licensed mental health treatment provider. It doesn't limit it to the outpatient or FSP. You may have called the PMLT, the crisis team, or individual may have a hotline in the hospital, also maybe have a court case, have interaction with the court language. Those licensed mental health treatment provider, they can also submit a AOT referral to link individual to AOT. And in fact, I think our biggest referral party are these three groups. If we take away the incompetent to stand trial referral by the court, in fact, those three are the biggest referral party of AOT. So you all are very important. Next slide, please. I also will spend a little bit more time in the AOT LA process. As I mentioned, for care court, they have two pathway. Mostly start with the petition, and another pathway is the referral. And AOT referral only have one pathway. We start with the referral. As you can see from the top, on the top right, AOT received the referral. And then the second one, we can see we review the medical record, we contact the referral party if it's by a licensed mental health treatment provider. Then we also have to contact the family. Or if the individual live in a housing or have a housing manager or apartment manager, then we try to get the information to determine individual whether it's eligible for AOT or not. Of course, I think if the individual live a family, just like I say, housing program, we also have to see whether we have the buy-in from the family for AOT to get in touch and make face-to-face contact with the individual, or the housing program manager will be able to assist in getting in touch with the individual. For example, the apartment have a gate, then we cannot get into the program, into the gate, to make contact with the individual. Okay, if we determine, we get the individual, the information, and then the case will be presented to the AOT referral review team. And then we have various party, we have the county council, we have sometimes law enforcement, the RAM team will be here. We in the past we have more representation, but now after the pandemic, we mostly within the team we discuss, but we will discuss whether we accept the case or not, and we do try to make the case acceptable. So sometimes the case may take a week or more, or almost a month to make it qualify, because we have to contact the family member, or there's a time that we have to find the witness, we have to explain why we need the witness. So we do try. At the same time, if individual really don't have the criteria, we'll explain, maybe how you can make it qualify. We also will discuss about safety plan and what you can do, and also provide resources and referral as well. Okay, if the individual is accepted to, the referral is accepted, we move on the left-hand side at the far left bottom corner. It's accepted. then AOT will start outreach and engagement for at least 30 days. In this process, AOT will try to face-to-face at least once a week. We provide psychoeducation. We discuss safety plan with the family, with the housing program or the treatment program. We try to solicit that voluntary yes from individual to engage individual in treatment, and hopefully to link individual to FSP and ERS program. We continue to screen and assess. Even though we accept the individual into the AOT, it doesn't mean that individual really meet criteria, because there's a time that maybe due to inadequate information, we figure out that maybe there's really, that ad is not substantial enough for us to move towards the petition, or we find that the hospitalization maybe fall off the time frame of the 36 months. So, but what I want to say is that we do try our best. If we have a case that we know that is the hospitalization criteria almost fall off, we just expedite everything and try to really move on to petition, so that we can keep that hospitalization criteria still within the allowable period of time. So as I mentioned, the process is we do the referral, we O&E, so we outreach engagement, and then individual refuse. Then AOT can opt to petition into the treatment. In this situation, even if the individual is linked to treatment, I would say yes. In fact, I just want you to go away. Yeah, I participate 2 times, and then no, I don't want anymore. Go away. Or just walk away. Refuse, just shut the door. Then AOT can still opt to petition individual to treatment. So if AOT determine that we are going to petition, we go through the process, have to submit the affidavit, go schedule the hearing, and this process can take more than a month. And in fact, from referral to really opt to petition can easily take 2 to 3 months. So it's not something that it's just a snap of the finger, then you say we accept and then we'll petition the following day. It's not like that. So for individual who accept and we petition, and the petition is sustained, and individual order to treatment, and individual order to 6-month treatment and can be extended for another 6 months or further extend. Care court is 12 months, AOT is 6 months. So individual will go to court hearing. So if individual is not stable, the hearing can be more frequent, weekly, bi-weekly. If individual is in the hospital and the judge really want to see how individual is doing in the hospital, can be 2 weeks, can be following week. But if individual is doing really well, can be 4 weeks and 6 weeks, to allow the treatment provider to help stabilize and provide further treatment to the individual. And treatment provider have to appear to hearing, have to assist the individual to appear to hearing in person or appear through LA Court Connect, the virtual platform. And our family members are more than happy to attend the hearing as well. But yeah, it's something that the judge really love to support, and also want to empower the family member as well. So in this case is that we would like to use the Black Book event to encourage individual to continue to participate in treatment. And as mentioned, Judge Herron had his way to really talk to individual to participate and get this voluntary participation. But we also have individual that really, no, I don't want anything. I don't care about have to go to hearing. I'm not going. I don't care. Individual, the treatment provider come to me. I'm not opening the door. Go away. AOT have an option of a 5346 hospitalization order for those individuals that really non-compliant, at risk of deterioration and need hospitalization. And we can work with the law enforcement and hospitalize someone, stabilize them, so hopefully continue to link them to treatment or get them back to the right track. Of course, I think we have individuals that graduate just a couple months, a month ago. We all really happy from seeing him at I remember the petition hearing. How can I get that individual to comply to treatment? But after a month, he is stabilized, he's very motivated, he graduate, and we are going to move him to a lower level of care, voluntary participate in AOT treatment. Some, we just see that continue to say no, and at the 3rd month or 6th month, at the 3rd month or 4th month of this treatment, we ultimately able to link them the treatment. So we are going to extend and the petition, another petition. Some, it just really, we can see we have a few cases on hand. After AOT, we still can't see individual able, even after 5346 hospitalization, still not able to comply, not cooperating. Then we just have to terminate. But we can see that doesn't mean individual who even failed AOT treatment, doesn't mean individual may need a higher level of care. So all this, of course, I think is difficult to see that the individual not able to do well even in AOT. But I'm going to say that there's a lot of successful story. Just like yesterday, I go to the court to see individual case. All those cases are very encouraging, and it just really stay in my heart and just pretty much motivate me to continue to keep going, because just the black rope effect, some work. We just have to try our due diligence and push forward one step at one time. For those who benefit, we just see that it's really benefiting. And we just have to remember those cases and just keep pushing. Next slide, please. Here, I want to spend a little bit of time to talk about what AOT does and does not. Of course, we talk about AOT in the past. AOT try to really push one step, push the due diligence and try our best. And in the past, the option is really one end is voluntary, free. You can choose, the total option, whether you participate or not. On the other hand is that LPS conserved, you have no option. You just have to follow the treatment determined by the conservator. AOT is a balance that, like the continuum, we try to solicitate that voluntary, but we also through the court order, the judge order you, so that you will be able to use the black book effect. Okay, I respect that. I follow that. I will participate. But sometimes, of course, we know that hospitalization is necessary. And we also know that individual, there's a lot of time that they need a high level of care. They may need forensic, because they're really doing a lot dangerous to other people, and there's consequence to their behavior. And there's individual that AOT, because we know the history, we advocate for a longer hospitalization. Please advocate to the hospital for a whole individual longer and medicate them adequately. Please give them a long-acting injectable before release. And at the same time, we have the provider, the treatment provider, to go and engage individual before they release from the hospital, and even work with the hospital to arrange placement, so that they will be able to, once released, hopefully have a chance to have a stable placement, will be able to have treatment as a continuation of care. And of course, the goal, we hope to reduce the violence, the crime, victimization. We hope that we can really prevent individual from deteriorating. But there's a case that I can see that just a couple of cases that you just see them have to deteriorate, that they have the free will or walk away. It's just sad, but we also have to accept the fact, Last but not least, just like Linda has been mentioned, that AOT-LA is a civil court process. We are strictly voluntary. We AOT order the individual with severe mental illness who decline to engage in treatment to intensive outpatient treatment. So they can refuse medication, they can refuse to engage, and in this, there's no civil or criminal penalty. We can't put them in jail, we can't say their consequence, but we do have as I mentioned, the 5346 hospitalization order. There's success, but there's also a case that the individual continue to just looping around and not able to cooperate. Next slide, please. Also, I want to quickly clarify misconception of AOT. As I mentioned, AOT doesn't lead to conservatorship. We don't have the option. We cannot apply for conservatorship. And we cannot mandate involuntary long-term hospitalization. If individual is hospitalized and AOT, the O&E and the FSP will be able to place someone on a 5150 hold if during that face-to-face contact, the individual does demonstrate danger to self, danger to other, or gravely disabled. And family member will also inform AOT if individual get hospitalized by the police or by the PMLD team. Then AOT will be able to, based on the history that we have about the individual, because AOT have access to different medical record like the Department of Mental Health, the hospital record. And based on your record, we know that individual have a long history of hospitalization. We can advocate. Please, this is what the client history. He really needs stabilization. Please, we have a plan. Hospital love to know that you have a plan. We have a plan, it's stabilized, you get the LAI, we are going to work with you to have a placement, we work with you. If the individual discharged, we'll have an FSP waiting for him, then the hospital is more willing to work with us. Of course, we know not every hospital is willing to work in the same way, but we try to advocate. So this is something that we want to emphasize. And AOT is the one that we won't say we accept, then we will have treatment. As you mentioned, as you can hear, I say we have to, investigate the individual really able to qualify, meet AOT statute or not. We have the outreach and engagement. And so in link individual to the treatment provider, it does takes time. We can expedite, but a lot of the time because individually may be sick for a while, they just really don't want anything. So it takes a little bit of time to really engage with them, build a rapport, explaining the program. Of course, the best is to have them to say yes and link them to treatment rather than have to say, okay, I'm going to petition you, even though it's an option. And AOT is not that something that you say, oh, hospital discharge, hey, AOT, you have housing, please. Some hospital program misunderstanding AOT will be able to link to housing immediately. No, if the individual is linked to FSP, then FSP as a treatment provider will be able to work with the hospital and identify housing and placement. But you know that a lot of the time it's not that easy. It does take time to locate the appropriate housing as well. And some service area is easier than the others. And AOT is not a team that will respond around the clock when the individual is in O&E. FSP does have a 24/7 crisis line number. And of course, the family, you think individual is not safe, danger to self, danger to other, or gravely disabled, don't wait. Call the Department of Mental Health, the 24/7 crisis line number, or call police if individual really demonstrate imminent risk and you need someone to respond immediately. Don't wait. So as I always mention, AOT cannot force medication. Even though the judge is really good, is able to talk to the individual and say, this is treatment, and able to let them know part of the treatment is medication and try to encourage them to take medication. We do see individual taking medication stable. We do see individual that just engage in case management and therapy and still trying to establish that treatment medication compliance. Next slide, please. Here, I want to show you two referral forms that I mentioned about. For example, in this situation is that, for example, you are the one that you want to refer your uncle or your aunt, but you are not living with your aunt, but then you are able to put maybe your mom or your dad as the referral party on the left. And then you are the one on the right-hand side, the purple circle. You are the one who complete the referral because you have all the information. And then if the individual live in the apartment, also put down the apartment manager contact that who is willing to help individual to help AOT to have the access. So sometimes not everyone will be able to complete this referral form. If the referral form on your hand doesn't look like this, that means maybe outdated. And also, of course, AOT asks for a lot of information. Just try to provide as much as possible. Because if we get the referral, AOT, the staff assigned, will call the referral party or call the family member to get more information. Next slide, please. There's a time that, as I mentioned, is the treatment provider, PMLT, outpatient, FSP. You hear that sometimes home team, ECM, even care court. The individual, if they are case manager, they are not the licensed treatment provider, so they cannot put their name. They are not licensed. How about that? They are not licensed. They are just not licensed. They can put the name at the person who complete the referral form, but they put the family member as the referral party. And then they can submit this referral form. Of course, they have to have the buy-in from the family member to submit this referral form. And if you get a call from AOT, please return the call. We have a number of cases that we have to hold on a referral because the family member did not return our call and just or refused to answer our call. And we have cases that we have to disenroll the individual from the AOT or even a dismissed petition because family members say, don't come. I don't want you to get in touch with my beloved. Just leave. We are fine. And even though as a professional, we see individual is deteriorating and at risk, but if family members say no, at this moment, we cannot. So I think your participation and your cooperation is very important. AOT to work together as a family, just like a team, and work together and help individual. Next slide, please. So this is something that I really want to highlight. There's hope. You know, AOT continue to want to make the difference in the lives of individual and provide the support. Hopefully, they can thrive in the community. AOT have been in DMH AOT has been in the LA County for almost for 10 years. We have very established relationship with the law enforcement, like the MED team, the LA Sheriff Department, the LAPD, individual city police department. We have been, for the individual who demonstrate risk to others, they willing to come with AOT to do outreach and engagement. If the hospitalization, the individual refuse to get on the gurney, if the individual have barricade themselves, individual walk away, we are able to get the law enforcement to plan and strategically plan how to execute a hold, try to increase the chance of placing someone on a 5150 hold. We also work together with law enforcement to tackle some more challenging case. And we work with various DMH and non-DMH program to really try the O&E together. We also, as various point of the time, we also have presentation to various program to let them know AOT so that they will be able to refer the case because some program, they also hit a wall. For example, I have a meeting with the ECM, with the PMLT, with the Homeless for Health. There's a lot of cases that really need a higher level of care or they need further engagement. So we just have to brainstorm what will be the next step and how to tackle those cases. And as I mentioned, we have partners of court linkage, we have jail staff, hospital liaison. We also have the home team, the FSP, outpatient care court, and a lot of non-DMH non-DMH program but contract agency also refer to us like People Concerned, like Step Up and Second, and we have a big load of collaborative partners. And one thing I want to say last but not least, I think is about family involvement. I'm really big to say that family is a hero. I want to make it one more time clear, family is the hero. We professional, maybe once a week, see individual for an hour, maybe more time, 3 hours, but you are the one who spend time 24/7. You live with them. Even though you don't live with the individual, but they are your beloved. They are always on your heart. Your cooperation and your working with AOT and the individual program is extremely important. I know that it's very frustrated. The longer the person has been sick, it's more difficult to engage. But don't give up. As you can hear from me, there's hope. And I want to highlight one or two successful stories. That, as I mentioned, there's an individual, has been sick for a long time. The father come to the AOT court to testify against his son act of violence towards him, push him to the floor, and he's really scared for his safety. At the court, he pleaded the judge and testified the act of violence the son towards him. But at the same time, he pleaded the judge, please order my son to AOD treatment. After his testifying, after the judge ordered his son to treatment, everybody in the courtroom, the judge, the public defender, the county counsel, DMH, there are no dry eye in the room. Just everybody get very touched. And then after the individual get hospitalized, stabilized, long story short, linked to treatment, and in fact, I see him back in the court. He come in person, the mother drive him, appear. He's a totally different person, smiling, and he said that he want to go to the community, take walk, and the judge would say, have to provide the judge, take him, maybe instead of meeting him, in the house, go take a walk, go to a cafe. So it's just really nice to hear that. And then you can see the smile on the mom face. The mom say, I'm going to go take a trip. I'm really happy, very touched. It's just like a Christmas gift to her. So, and we have other successful story. As I mentioned, we also have other story that we are still working on. But those successful story, the case that we see and how hard the team work, I want to say those stay in my heart and keep pushing me to work on what I can do. Next slide, please. So here's the AOT LA contact. You can see we have the general service line number. We have the email address. And feel free to go to the website to get our referral form and also get our various brochure in various language. And here's my email address. And feel free to reach out to me if you have a case that you want to consult me. And thank you so much. And here's my presentation. And I appreciate everybody who come to the this presentation today. Thank you.